All right, Mr. Kendall, I am ready for you to put what you want on the record concerning your motion for mistrial.
Judge, I don't have anything to really add other than what I've already written in this motion. I will just suffice it to say that going forward, I would like to have the opportunity to be able to read these questions before I'm asked to make objections to them so that I can see on a contemporaneous basis which questions you asked and which ones you did not ask. I think it's incumbent upon counsel to make very cogent and specific objections from the cases that I have read, the cases that I have read where the courts have said the objections were not particular or did not specify what the objection was. I find it almost impossible to make a cogent objection to something that I don't have in my hand to read. So I would like to get a copy going forward, if this motion is denied, to have a copy of each question that is asked so that I can check off which ones were asked and which ones were not asked. Because I asked you if you were to read into the records the ones that were not asked and you declined that request.
So I'm clear, it wasn't, I guess it's not clear to me what the basis of the mistrial is. Is it that certain questions weren't asked, or it's the procedure whereby I guess you're not given copies of the questions? I need you to particularize it for me. I don't want to miss part of the motion.
My motion is to both of those concerns. The fact that we were not given copies of the questions so that I can make a particularized objection, and to the particular questions that were asked, because I believe the one question that stands out in my mind is a question that I mentioned in this motion. And there were similar questions that I cannot precisely recall that were also not asked. So my objection is both procedural and substantive. Going to procedural due process in this proceeding, as I have described in this motion. Not asking particular questions, which then renders jurors to believe that they are being slighted for whatever reason. There's one case, I think it's I can't remember the case, it's the Scott case, I believe it is, that says that the court should give the juror who is not the recipient of a question that is asked an explanation, or the jury as a whole an explanation as to why a particular question has not been asked. That has not been done.
Okay.
All right.
Anything from plaintiffs on this matter?
Only to note that in the case that Mr. Kendall cites in his motion, Your Honor, Story versus State, 157 Georgia Court of Appeals at 490, the court says to allow unrestrained questioning of witnesses could be disruptive to the court or prejudicial to the parties. To avoid prejudice, the juror questions should be presented to the court outside the hearing of other jurors. If the judge determines that the question is relevant and proper, he may confer with attorneys for any objection they may have to the question. The court followed that exact procedure here, and the question that Mr. Kimbrough objects to was determined not to be relevant to the issues in this case, which are court funds. We believe that the court followed the proper procedure and we would oppose a mistrial.
Okay. So I'm going to deny the motion. I'll explain why. On the substantive basis, so far as I recall it, well, I'm going to rewind. I'm going to work with process first because that will reflect the way in which we've been working through this. Jurors were told before any evidence was presented that they would have an opportunity to submit potential questions for each witness at the close of direct and cross-examination. They were told in the same breath that they should draw no conclusion, inference, or put any weight on the fact that some of their questions may not be posed. And I went on to explain that just as lawyers can Jurors can ask questions that are not appropriate. It might call for hearsay, it might be irrelevant, or for some other legal reason, the question may be improper. I'll be repeating that instruction at the end of the trial. I believe that that is sufficient. This process has been challenged, my process specifically, before the Supreme Court, not the Court of Appeals, and upheld several times. In fact, Mr. Kendall cited the first case, Hernandez, when the Supreme Court, understanding the process to work the way it is working today, approved it as being sufficiently mediated by the court so that it was not disruptive and jurors weren't shouting out questions or just speaking questions when they had one. And so I'm comfortable that this process respects due process. So we're clear. At the close of each witness's testimony, jurors have handed up 3x5 note cards. Mr. Kendall and Ms. O'Neill or Ms. Tucker, depending on the witness, have had an opportunity to review every question that was submitted. During that review, in my experience, some attorneys have jotted down notes based on what the questions were. And that's the way they keep track of things. Of course, the record will have every question that was submitted. I've said that on this record several times now. I have in front of me what will be Court's Exhibit 1, and it has all 36 note cards that were submitted. So there will be a clear record of what questions were asked and what questions were not asked. It's not difficult to divine which questions weren't asked because there have been very few objections to the questions that were proposed. There were a handful of sua sponte objections. I found several questions to be not relevant. It's important to get on the record that Mr. Kendall told me that his belief is if a juror asks a question, it's relevant to that juror and it should be allowed. I suspect, should a juror submit a question after Mr. Hyder finishes testifying, has Mr. Hyder ever been convicted of a crime, Mr. Kendall will find that to be not relevant and won't want it to come in. And I concluded that several questions weren't relevant to the issue of the business tort and the potential contractual breakdown between the parties in this case. That said, the questions that I did not ask are in the record. And if this case ends in a manner that's not favorable to Mr. Hyder and Mr. Kendall wants to appeal, he will be able to highlight for any reviewing court the decisions that were made not to ask certain questions. And if those are deemed to be substantive errors, the higher courts can react to those. That's why I keep all the questions. I've also given the lawyers a chance to get on the record what their objections are, not in the presence of the jury, but when we take breaks. And I'll continue to do that. I have found, and the higher courts have found, that that process reflects due process. So, Mr. Kendall, I invite you to jot down what you want to based on the future questions that are submitted. You elected not to do that to begin with. You will not get copies of the questions that are submitted, but you're welcome to have a copy of Court's Exhibit 1 when we're done with the trial, although it'll be part of the record. In terms of I guess this would be what you'd call your substantive basis for the mistrial. There have been, I think, 2 instances, you identify only one, but 2 instances when your term was a socially conscious juror, rendering the other socially unconscious. But the socially conscious juror had a question, actually it was 2 different jurors based on handwriting, had questions that I deemed weren't relevant. This is when you and I had the exchange about, well, if a juror asked the question, it must be relevant to the juror, so you need to ask it. That is an approach that you're free to articulate. Should you appeal the outcome of this case, good luck. So I found those to be not relevant. I made clear to both sides I wouldn't be asking them. And true to my word, I did not. Those questions are right here in Court's Exhibit 1, so they will be subject to review at the appropriate time should someone ask to review this process. But we're going to continue it the way we've been doing it in this case and the way I've been doing it in all cases. I look forward to redirection from an appellate court should an appellate court conclude that in some way this process disadvantages a party to such a degree that it is violating their due process rights. How are we doing with jurors? Thank you. Let's talk about taxes. Mr. Kendall, when did you learn from your client that he remembered that he in fact hadn't filed taxes for American Business Group or for Bristol Consulting? Because as I understood the email, and it wasn't sent to me, it got forwarded to me, the answer from your client was not, I couldn't find any, but in fact, I never filed any, or I haven't filed them yet.
Well, my understanding was that he went to the warehouse. He's in the process of moving. He's moved out and sold his previous residence. So he's moved to a temporary residence in another county. And he went back to the warehouse on Saturday to look for, and I'm not sure it was Saturday or Sunday, but we talked on Sunday, to look for the tax returns. He found his personal tax returns. He did not know which years he had not filed business tax returns. And when he went to the warehouse, he did not find any business tax returns for the years that were requested. And that was, I'm not sure when he did that. I found out about it on Sunday. And we talked in the morning, we talked again shortly before 5 o'clock, because he said he wanted to look at another location to make sure he did not have the business tax returns. He called me back about 15 minutes to 5 and told me that it was confirmed he did not have business tax returns.
Well, I'm pressing you on this because there's a difference between, and I don't want someone to ask a question from plaintiff's side that's improper. There's a difference between I can't find them, and I understand you've moved and there was a burglary in the warehouse, et cetera. I can't find them, but I did file them, and I didn't file them. And the email I saw was I didn't file tax, or American Business Group did not file taxes for the relevant years, and same for Bristol.
That's correct.
Okay.
But he found tax returns for other years, not requested.
Okay.
For those entities, for one, at least one of those entities.
Okay. But for the years in question, based on the notice to produce, the answer isn't I couldn't find them, it's I didn't file them.
For those years in question. Yes.
Okay. But on the personal side, he did find them, and thank you, sir, for looking for them. And you've got those. And as I understand it, Ms. O'Neill has for the brothers Dalton, as well as D2, the corresponding returns, state and federal, for those same years. Is that correct, Ms. O'Neill?
That's correct.
All right. You all can exchange what you want to exchange in a minute. Let's get a report about the jurors. Remember, please, no questions of witnesses about what's in tax returns until we've had a chance to talk about how they're going to be used, because they're sensitive, and because, most of all, Mr. Kendall's point, the financial circumstances of a party generally aren't relevant to the issues in a trial, absent punitive damages, et cetera. And that's not where we're going. So I want us not to hit any tripwires with these documents. It may well be that these documents lead to appropriate questions, but we ought to discuss those outside the presence of the jury before those questions start flowing. Ms. O'Neill, understand?
I understand, Your Honor.
Mr. Kendall.
One other question. You, I believe, put me under the prohibition not to show my client the Dalton's tax returns. Is that equally applicable to the Dalton?
Yes, sir. No, these are, right now, the tax returns are for attorney's eyes only until we can have a discussion. The clients can be present for the discussion because we don't need to use numbers, a discussion on how on earth are we going to use these. As I understood, really from both sides, these were potentially conditionally relevant. The classic example you gave that may come to play, Dr. Dalton says, I didn't have that kind of money. And there's a tax return that shows you made $100 million. You know, it may well be that it's appropriate for you to explore that disconnect of I couldn't find $10,000, but I earn $100 million in 1 year. But you all need a chance to look, you, meaning the lawyers, need a chance to look at them before you could determine if they have relevance. Anything else, Mr. Kendall, on that front? Okay. Sure, well, hold on. Let's hear from Deputy Gordon. How are we doing? 11. All right. Do you have a attendance list? We'll get you one of those. And then if you could come back and let Ms. Niles know who's missing, we'll start working the phones. Can you check to see if it's live streaming? Because I got an error message, but then I tried again and it actually is asking me if I want to stop it. I don't want to stop it if it's going. It is great. It's not. It's a little delayed. Should have started my video, but there I am. I think it's working. Great. Thank you. Are we up a little?
Yeah, just one.
Just one.
Just the.
What number? Or the name? Oh, okay. One of our alternates. One left. Is Michelle going to give him a ring?
Of the reporter's head. She okay?
Oh, yeah.
The one that had to go there and see.
Yeah, I think she's six. Any questions or discussion?
I'm glad to hear someone like.
Yeah.
But we don't have any. Oh, so they could have been sending them away. We're not.
Good, but it's not less critical.
Yeah.
Unfortunately,
Scary, but
she kind of
it's not less critical.
Okay. Thanks.
Yeah, right.
I'm going to share that with Amy.
I did, yes, thank you. So you have that all. Pardon?
And promises. Do you want to get the same?
Yeah, I know.
This is national. Which has a copy of the deposition attached to it. And the two copies.
Oh, I've got his email.
Yeah.
It is.
Has a copy of the deposition attached
He's,
to it.
you can see he's 31.
The deposition to Carson, right here. This doesn't give it.
Oh, yeah.
Yeah, but it's that, it's the
Yeah,
full
yeah,
point.
yeah.
Great, thank you.
Yeah,
Just there's one other issue that I think we need to take up before Ms. Kimbrough testifies.
Okay. Do you want to get this on the record?
Yes.
Okay.
Thank you.
Okay, the plaintiffs filed a motion in limine. And I don't know if Ms. Kimbrough needs to be in here for this.
Okay. Ms. Kimbrough, if you don't mind stepping outside, we'll make sure to give you directions if there's anything that results from the conversation about areas we're not going to go into. But if you'd step outside, I appreciate it. Can Ms. Howard stay in here? Okay.
Stickies in here.
Plaintiffs filed a motion in limine regarding, I'm trying to remember the exact wording of their motion in limine regarding the lawsuit that was filed by D2 against Ms. Kimbrough. And we took that up at a preliminary hearing that was not recorded, and there's no order regarding the determination. And I'm having trouble recalling, due to my old age, what exactly is the ruling of the court with regards to what can and cannot be discussed regarding that lawsuit.
So I think there is a little bit on the record on that, because when we started, whenever we had jury selection on Tuesday, before the jurors were available, I recapped a little bit what our discussion had been about the motions in limine. Here's my recollection, but we can refine it. There were, I believe, two motions in limine concerning Ms. Kimbrough. Number two, which related to the unanswered questions. I think that's been addressed by having Ms. Kimbrough come in here and answer some questions before her jury testimony. It was a very long motion. And then number three, there was a motion from plaintiffs to exclude, and I quote, any evidence, testimony, reference, or argument related to the legal malpractice claim against Crystal Kimbrough. And you pointed out, Mr. Kendall, if memory serves, that it's kind of hard not to get into the existence of the lawsuit. And at a minimum, it could be, and I wasn't sure that it would necessarily be a reason for you to ask it, but one of the two sides might want to highlight that because it could be evidence of bias that Ms. Kimbrough could have ill will towards folks who have sued her for alleged legal malpractice. And so what I recall saying was that the existence of the suit, the fact that the D2 parties, as they're referred to in the motion in limine, have sued Ms. Kimbrough for legal malpractice is something that can be asked. But where I provisionally drew the line was getting into the status of the lawsuit, or more so the details of the claims. I think Mr. Kendall had argued that the claims are almost identical, and you were worried about double recovery, and that the Daltons and D2 were going after Ms. Kimbrough for the very same things they were going after Mr. Hyder for. And I cautioned you not to get into that level of detail about the malpractice suit, but its existence was something that could be explored. Does that refresh your recollection? You have a different recall, and I'll hear from plaintiffs in a minute, but that's what I recall us discussing and the direction that I gave.
I think that's accurate. That's what I do recall. My fuzziness on that, now that you have refreshed my memory, is going toward what exactly is that line that you're drawing, because there are certain facts that have come out in this case that may or may not be contrary to what I call facts in that lawsuit, as per an affidavit that the Daltons filed with the lawsuit, as they are required to do when you allege professional malpractice. And they verified the complaint in that particular lawsuit, which serves to adopt and verify the affidavit that was filed. So the question I have is, these facts that are listed in that affidavit, to what extent can I talk about those facts listed in the affidavit of attorney John Marshall Martin III, insofar as those facts may be inconsistent with testimony that has been enlisted in this case?
So a couple things. One, why would whatever attorney Martin averred be relevant here? He's not a party. He hasn't been a witness.
Why would it be relevant?
Sure. Or not hearsay, or, I mean, we don't have Mr. Martin here to say that's not what I meant, or that is what I said. It's not Dr. Dalton or Brian Dalton saying any of those things.
It's Brian Dalton and John Dalton saying those things because they have verified the complaint that was filed, which included the affidavit of John Marshall. So that verification of the complaint is tantamount to adopting his statements.
Okay. Well, let me hear from whichever member of plaintiff's team wants to first confirm that what I described as what I thought were the guidelines, and they're guidelines. Something could have come up during trial that changes the way we ought to work through it. As Mr. Kendall mentioned, we've now heard some testimony about Ms. Kimbrough's interactions with either the Daltons or Mr. Vackman or Mr. McGuire, and those could change what makes sense to admit and what doesn't. And so Mr. Kendall can maybe give us some specifics in a minute, but I'm wondering, one, if you recall the same guidelines, and then two, your response to this argument that because the Daltons verified the complaint, whatever Attorney Martin said in his affidavit is, I don't know if Mr. Kendall's calling it a fact, but it's something that the Daltons have owned, and it can be brought up and discussed, I guess, with Ms. Kimbrough.
So first, yes, my recollection is consistent with the court's. Second, I believe we addressed this. We were arguing motions initially, and the legal malpractice complaint merely contains allegations at this point in time. The impairments that are in the affidavit from an attorney who is not a witness in this case is not relevant to Ms. Kimbrough's testimony here today. Perhaps if Mr. Kimbrough wanted to use that affidavit to impeach my clients when they were on the stand, that may have been appropriate. But certainly it's not appropriate to get into that affidavit that Ms. Kimbrough, you know, she has knowledge of it from it being served on her, but she's not the one making it.
Okay. Mr. Kendall, give me an example, please, of something you'd want to do using the affidavit. What's a question or a line of questioning, just so I can better assess?
Okay, we have allegations about the fact that Bristol received the Plaza property in a separate transaction from the transaction involving the apartments. And in the affidavit, the attorney alleges that Ms. Kimbrough committed legal malpractice because she failed to file a Bristol deed until after the closing of the Verbena Street properties and failed to advise the daughters as to an appropriate amount of title insurance coverage, et cetera. So to the extent that the plaintiffs have alleged that these acts, that is him getting transferred the Plaza to himself and a separate transaction was an incident of fraud, it's relevant that they have also claimed that that is a tort on behalf of Ms. Kimbrough because she was the one that actually carried out the dirty deed, so to speak. No pun intended. But that's an example of what the plaintiffs have claimed against her, that they are trying to, at the same time, slide over and say that it's his fault, Mr. Hyder's fault. So I found that to be a certain incongruence between these allegations in that complaint and the allegations that are in this lawsuit.
But why wouldn't you ask Mr. Hyder when he's on the stand, did you tell Crystal Kimbrough to do this? And if his answer is no, I didn't, then you've got a good defense to some of these allegations in this suit, not the legal malpractice suit, which we're not litigating here. Because that's been a constant theme of yours, and I appreciate it, that there seems to be an effort by plaintiffs to say Kimbrough did X and Y and Z, all of which were designed to further the alleged fraud that Mr. Hyder was in the midst of. I don't understand why you need anything from the malpractice lawsuit to ask Ms. Kimbrough, did she do these things? Did she do them at Mr. Hyder's direction or her own volition? I mean, I assume that's where you'd want to go.
Yeah, you're going to allow me to ask those questions.
Did she do certain things that we've heard about in this case?
Right.
Of course.
Okay. Well, to that extent, I may not need to get into it.
I don't think you do. If you feel like you've been backed into a corner by this ruling, let's take a break and talk outside the presence of the jury. But I think you're free, and I'll let Ms. Tucker say, here's why I disagree, Judge. I think you're free to ask Ms. Kimbrough about any of the things we've been talking about in this trial. There's this allegation that you did X. Did you do that? Did you do it at Mr. Hyder's direction, et cetera? It may also be in the affidavit or that legal malpractice complaint, but that's not why I assume you're asking it. You're asking it because someone here, either in a pleading in this case or a witness, said, yeah, and this was bad. And it was all Mr. Hyder's doing.
Right.
Okay.
It basically made Crystal Kimbrough to be the agent of Donnie Hyder.
That would be one way that you could fairly argue the evidence. I think that's right.
Yeah. So to the extent, I'm saying to the extent that they also allege in another separate proceeding, which the court can take judicial notice of, by the way, and we would ask that you do take judicial notice of this lawsuit, that they're claiming that she did these things on her own without any mention of Mr. Hyder being her master in doing these things. That's where the incongruence comes in. One lawsuit, they say it's all your fault, you did it all. And then in another lawsuit, they say, well, she did it, but she was your agent.
Okay, I don't read the lawsuit quite that way based on the nature of the claims, but it sounds like right now you feel like you've got the leeway you need to explore things with Ms. Kimbrough. If you feel like you've run into some obstacles because of my ruling, then let's pause and discuss it more. Ms. Tucker, anything you want to add?
We agree with the court's ruling. We would note that the affidavit itself should not be admissible, but the underlying facts of the affidavit and touch on the issues in this case and are relevant. I would also note that paragraph 8 in the affidavit that's attached to the legal malpractice complaint talks about a promissory note. And we've had a lot of testimony here about how that promissory note was requested by Mr. Hyder.
Okay, well, I didn't hear, thank you for that addition. I didn't hear Mr. Kendall saying anything about trying to tender or publish the affidavit. That would be a leap from where we are right now. So I think we understand where the line has been drawn for now. And if we need to revisit the propriety of that ruling, I'm happy to do that. I hope we have our last juror now. But everyone who could answer that question has left the courtroom. Do we have an update?
We left him 2 messages.
To your email.
Okay. But when we see Deputy Gordon again, we'll see what's happening. And Michelle hasn't received any messages.
No.
Everyone's here. Fantastic. All right. Ms. O'Neill, anything else before we bring our late jurors in? Mr. Kendall?
Nothing else.
All right. And Ms. Howard, if you don't mind getting Ms. Kimbrough, she can come on in. Thanks. So let's get the jurors.
Yes. Put it in my pocket. Took it down.
Yes, you got this on the front page. So let's compare them. So you have to research.
You all can be seated. Good morning, ladies and gentlemen. Happy Monday. It's great to see your smiling faces again. I assume you're smiling. You've got masks on, so I can't tell, but I know you're happy to be here. I hope you all had a good weekend, stayed out of trouble, didn't talk about this case or conduct any outside research. We were ready to go at 9:30, but things happen, and we're going to get underway. We were in the midst of Mr. Kendall's presentation on behalf of his client, Mr. Hyder, and the two corporate entities, American Business Group and Bristol Consulting. Mr. Kendall, if you will call your next witness, please.
We call to the stand Ms. Crystal Kimbrough.
Ms. Kimbrough, if you come on up, please, to be sworn in.
Yes. Yes, my name is Crystal Kimbrough. It's spelled Cristyl, last name Kimbrough.
Okay. Ms. Kimbrough, could you tell the jury how you are currently employed?
I am currently employed at Kimbrough Law, real estate law firm.
Okay, is that your law firm?
Yes, it is.
And what kind of law do you primarily practice?
Real estate closings.
Okay. Within the field of real estate closings, can you describe to the jury what you actually do as a real estate closing attorney?
Sure. As a closing attorney, we ensure that title to the property is clear and marketable, there aren't any liens or encumbrances that could attach to the property post-closing that may be associated with a buyer or seller.
Okay. Do you typically research the title to properties?
Every time.
Okay. Do you prepare documents that are utilized in the transaction to document the transaction?
Yes.
Do you typically file those documents in the recorder of deeds here in Fulton County and other counties?
Yes.
What percentage of your practice as a real estate closing attorney is divided between residential and commercial transactions?
Commercial is roughly 5%. Residential is 95%.
Okay, so is it fair to say you primarily consider yourself a residential closing attorney?
Well, we close residential and commercial, but mostly residential.
Okay. How long have you been practicing law?
Since 2012, I think.
Okay, so this will be roughly 9 years this year.
Yes. Yes.
And how long have you been in the practice of real estate closings?
I've solely practiced in real estate law.
Okay, so have you done that since the inception of your practice?
Yes.
Okay. Now I want to draw your attention back to the year 2016. Do you recall doing closings during that year for D2 Properties and Donnie Hyder or any of his associated entities?
Yes.
Okay. Tell me what kind of relationship you had with Donnie Hyder and D2 Properties during the year 2016.
So I would serve as the closing attorney on the transactions that they would close. Some of them were investment purchases, some of them were refinances. And I can't remember how many in 2016 specifically.
Okay. You closed a number of residential real estate properties in which Mr. Hyder and the D2 Property Group was involved, right?
Correct.
And when you perform these transactions for them, was one party the buyer and the other party the seller, or how did that work?
It's been where Mr. Hyder was assisting Mr. Dalton in refinances, which were refinances of residential properties, if I remember correctly. There have been transactions where it's been just straightforward purchase transactions. But in some closings, Mr. Hyder would be assisting Mr. Dalton in putting the deal together, is what we call it in real estate.
Okay. Are you familiar with the term a flip transaction?
Yes.
Okay. Can you describe what that is for the jury?
So a flip transaction would be the purchase of property, renovating it, and subsequently selling it for a higher price to receive profit.
And in flip transactions, is it common for there to be a simultaneous purchase and resale of the property in virtually either the same transaction or contemporaneous, immediately succeeding transactions?
Yes.
Okay. Were any such transactions of that nature involved in any of the transactions that you performed in which Donnie Hyder and D2 Properties and John Dalton and or his brother Brian Dalton were involved?
Yes.
Okay. Can you give me an idea or give us an idea of how many transactions you performed for these parties were of that type?
I can't remember flip transactions specifically. Transactions involving both Mr. Dalton and Mr. Hyder was roughly 8 to 10 with both parties involved, but I can't remember specifically how many were flips.
Okay. Now, of those 8 to 10 that you actually performed, did you ever have any difficulties or complaints from these parties about how you had conducted the transaction?
No,
Do you recall a commercial transaction involving what we have referred to in this litigation as the Verbena Street properties?
yes.
Can you describe?
Could you clarify what parcels you're referring to when you say the Verbena transaction? Just,
Yes, when I use the term Verbena Street properties, I'm speaking of both the commercial and the apartment, multifamily residential properties. Okay?
yes,
And when I describe one or the other, I will say either the retail property or the shops, or I would just say the apartments.
okay,
But when I use the term Verbena Street properties, I'm speaking collectively of a group.
okay.
Okay. So you do recall that transaction?
Yes.
Okay. Describe what your role was and what your job was in that transaction.
So my job was to ensure that title to the property, both the commercial tract and the residential, was clear and marketable, that there wouldn't be any liens or encumbrances post-closing.
Okay. Do you feel that you adequately performed your job in that transaction?
Yes.
Okay. I want to ask you about the retail or commercial tract. Now, is it your understanding that that tract in this grouping of properties was to be transferred from the seller to an entity owned by Mr. Hyder, which was, in this case, Bristol Consulting Group?
Yes.
Is that the way you documented that transaction?
Yes.
Is there any thing that comes to your mind that indicates to you that when you documented that transaction, the Daltons or D2 did not understand that Mr. Hyder was to receive that particular tract?
There was nothing that came up. To my understanding and recollection, the residential parcel was abandoned, but the commercial parcel was not. At the time of closing, Mr. Dalton did not ask about any current lease agreements. He didn't ask about keys to the commercial tract. Nothing that would indicate that he was to receive or be titled the commercial property.
Do you recall if you had any explicit conversations with Mr. John Dalton or anybody else, Brian Dalton or D2 or anybody representing D2, that the retail tracts were not to be transferred to D2?
No.
Did you yourself ever go out and view this property? The Verbena Street property?
I believe that I viewed the property post-closing, but not physically pre-closing, which is common. As closing attorneys, we rarely actually see the properties that we close on.
Okay. Now, there has been a lawsuit filed by the Daltons against you, right?
Yes.
And that lawsuit is still pending, right?
Yes.
Okay. Just 1 second. Pull up something here. Now, the closing documents. How do you handle closing documents between the various parties, sellers and buyers, do you send them out prior to the closing? Or do you ask people to sign them when they come to your office to execute documents?
So typically the settlement statement, which is the form that summarizes all of the fees associated with the transaction, that's typically sent out prior to closing because parties need to know how much to wire. And sellers want to know how much they're, going to receive in proceeds. But the closing package is explained at the closing table.
Okay. Now, in the case of these residential properties that you had, these 8 to 10 residential properties that you had done for Mr. Hyder and the Daltons, did you use the same procedure there that you used with the Verbena Street apartment property?
Yes, the only exception I think would be, I think at one point in time, I emailed what's called a promissory note. Because this transaction wasn't as straightforward as just a typical residential transaction, I needed to ensure that both parties were on the same page about the terms of the agreement. So I believe that some of the closing package was emailed prior to.
Okay. Now, let's talk about that promissory note for a second. Why did you issue a promissory note?
So a promissory note is essentially a contract between the lender and a borrower stating that they promise to pay the loan back. I was informed by Mr. Dalton and Mr. Hyder that, and which promissory note are you referring to? Because
I'm referring to the promissory note that the Daltons signed for $1 million to Donnie Hyder as the recipient of that promissory note.
Because there were two promissory notes because there were two mortgages that Mr. Dalton was receiving. So you sign a promissory note per mortgage. So for the promissory note that you're asking about, Mr. Hyder and Mr. Dalton came to an understanding that for Mr. Hyder's compensation for structuring the deal, Mr. Dalton was to give Mr. Hyder $1 million during the course of the term. And I can't remember what the term was as far as when the 1 million was due.
Okay. And in your experience in doing these transactions and doing a transaction like this, was that unusual for a purchaser of a property to give back a promissory note to the seller of the property?
No. You have certain deals that are called seller financing, where essentially the seller would act as a lender. And it's not unusual for someone that is structuring the deal to be compensated for their service.
Okay, now, in that type of a situation where the seller, in this case, with regards to these apartment properties, as you documented it, the seller would have been whom?
Well, the residential lot went to Mr. Hyder, which was an apartment complex, and the commercial tract went to Mr. Hyder. So at the time of closing, it's like a simultaneous transaction. So at the time of closing, Mr. Dalton was the owner of the apartment complex. And at the time of closing, Mr. Hyder was then the owner of the commercial tract, which would then make him a seller.
So are you familiar with the term purchase money mortgage?
Yes.
Can you define that, please?
So a purchase money mortgage is essentially providing money for or providing a service in lieu of money at the time of closing for a mortgage.
Okay, now, in the documentation of this transaction, you attach certain legal descriptions to the security deeds and the limited warranty deeds that were involved in this transaction? Do you
Yes.
recall that? And do you recall that the commercial tracts, there were two commercial tracts, and that the legal descriptions to those two commercial tracts were attached to the apartment tracts? Do you recall that?
Inadvertently, yes.
Okay, that's my question. Did you intentionally do that, or was that an inadvertent mistake on your
No,
part?
my office inadvertently attached the wrong legal description, which unfortunately was human error and happens in real estate closings. We subsequently filed an affidavit of record to clarify the mistake.
Okay, so let me ask you this. After you clarified the mistake, did you notify the parties to this transaction that this matter had been clarified?
I can't remember.
But as you sit here today, are you 100% sure that that matter has been rectified?
Yes.
Okay. Now, in the transaction involving the apartments, the sale and purchase of the apartments, was D2 your client?
Yes.
Okay. And how were you paid?
I was paid at the time of closing, like all parties. So the settlement statement is finalized after all parties agree to what's on the statement. And then it's up to the closing firm to disperse proceeds according to the settlement statement.
Okay. And in this particular transaction, the funds that were dispersed were provided by whom?
Well, technically the lender, because the buyer received a mortgage for the purchase of the property.
Okay.
Is that what you're asking?
Yes. Was that lender a company called Fowler Financial?
I believe so, yes.
Okay. And did you have any interaction with an attorney by the name of Sam McGuire?
Often.
Okay. And did Sam McGuire provide you with certain documentation that you utilized in closing this transaction?
Yes. Sam McGuire's office is the company that prepared what's called a subordination agreement. You have a subordination agreement whenever there's a superior mortgage and an inferior mortgage. And that document, I know specifically, I remember, we also have to work with Sam McGuire's office to finalize the settlement statement because it has to be approved by the lender. But it was a lot of back and forth between our office and Sam's office.
Okay. Can you, if you can, I know it's been a while since this transaction took place, but can you recall which documentation Mr. McGuire provided and for whom?
Which document he provided?
Which documentation? Did he prepare, for example, a security deed on behalf of Fowler Financial?
Yes. So there are security instruments that have to be filed in public record. And typically in real estate closing transactions, the lender's attorney prepares those security instruments. And that was not unique in this situation. So Sam McGuire's office prepared those security instruments.
And was that security interest of Fowler Financial in priority over the $1 million promissory note that we just talked about?
Yes, Sam McGuire's client had the, and I can't remember the lender's name, but Sam McGuire's client had the superior mortgage and Mr. Hyder's company had the inferior mortgage.
Okay. Now, in your knowledge of real estate transactions, if that superior mortgage is foreclosed upon, what happens to the inferior mortgage?
It's typically wiped out. If there wasn't enough equity in the property to cover both the first and the second mortgage, and the second mortgage is just wiped out, leaving only the promissory note, which is the contract between the lender and the buyer promising to pay the loan back.
Okay. Do you recall when the Daltons signed the promissory note?
At the same time, they signed everything else at the closing table.
Okay, when they did that, did they come into your office to do that?
Yes,
Okay, at that time, did they, or any one of them, whomever signed it, did they express any reservation to you about signing that promissory note?
no,
Did Mr. Dalton's, or John Dalton or Brian Dalton ever tell you that they felt that promissory note was invalid?
no,
Did Mr. Dalton or John Dalton ever tell you that they were only signing that promissory note because you told them to sign that promissory note?
no. I would have, so the promissory note details the terms of the repayment. So I could only get the terms of the repayment from parties. I couldn't make up the terms of the agreement because the closing attorney doesn't negotiate the terms of the agreement. We memorialize it.
Yeah, I think that's all I have as witness at this time.
Ms. Tucker?
Okay. Good morning, Ms. Kimbrough.
Good morning.
And my name's Sarah Tucker, and this is the first time we've met today, correct?
Yes, it is.
Okay, and you're a lawyer, that's correct?
Yes,
You started practicing in 2012.
yes,
You went to law school at Southern Law in New Orleans,
in Baton Rouge.
Baton Rouge, excuse me. And you're a member of the Georgia Bar,
Yes.
but you didn't pass the Georgia Bar on the first try.
No, I passed on the third try.
And you've been doing real estate work since you started practicing in 2012.
Yes,
And you just testified that about 95% of your real estate practice is residential, correct? So at the time of this multi-million-dollar transaction in 2016, you had about 4 years of residential real estate experience.
and commercial.
And you wrote the title commitment on this transaction, correct?
Correct.
The title commitment is the document a title company or real estate law firm creates as a promise to issue a title insurance policy, right?
A title, to clarify that, a title commitment sets forth everything that will be covered in the title policy and everything that will not be covered in the title policy.
Right, so it's basically a roadmap that the title agents use to cure any defects in order to transfer the title free and clear.
You can say that.
And you wrote title for First American Title at the time,
Yes,
but you no longer write title for them
correct,
due to what you call a mutual termination.
correct,
And you now write title for a different company.
correct.
At your deposition, you were questioned by Ms. O'Neill on behalf of the D2 parties.
Yes,
And you were questioned by Mr. Kendall on behalf of Donnie Hyder, Bristol, and ABG, correct? You had a fairly long deposition, is that right?
yes,
I think it started at 9:45 and it went until around 3:30 p.m. Does
okay.
that sound right?
It sounds right. I think so, yes.
And you all took a lunch break, yes?
Yes,
And over the lunch break, you discussed your testimony with Mr. Kendall.
well, I discussed more specifically how I felt a little uncomfortable with the aggression that Miss O'Neill was having with me, yes.
So you talked to him about how things were going in your deposition.
Well, no,
I'm gonna object to this line of questioning. I don't know what relevance this has to anything. If she wants to impeach the witness by what she stated at a deposition, then she can ask a question. If the witness answers inconsistently, then there's a procedure for doing that. Just asking general questions about a deposition has no place and is improper.
The relevance is that it shows bias that Ms. Kimbrough is speaking to the attorney for Mr. Hyder.
Okay, you have been able to ask a couple questions about that.
Okay.
Let's move on.
You believe that Mr. Hyder was an agent for the Daltons.
Yes,
Because Mr. Hyder would act on behalf of the Daltons and D2 Property Group.
yes, in several transactions.
And your belief was based on the Daltons regularly deferring to Mr. Hyder's judgment.
Well, no, my belief was that when I reached out to Mr. Dalton, he would direct me to Mr. Hyder in several transactions.
And you remember giving a deposition in this case. It was in December of 2018.
Yes,
And your testimony today is that it wasn't your belief that the Daltons were regularly deferring to Mr. Hyder's judgment?
no, I agree with that was my belief. I was disagreeing with your reasoning.
Okay. And you never saw anything in writing from D2 Property Group or the Daltons actually authorizing Mr. Hyder to act as their agent for this transaction?
No, just about 3 or 4 years of transacting with them.
You agree that the Daltons were relying on Mr. Hyder to provide accurate information?
Yes,
And would you agree that Mr. Hyder held himself out as an expert in real estate?
I don't have the expertise from an agent standpoint to know whether or not he fulfilled his duties as an agent.
If Mr. Hyder admitted that he gave you the instructions to prepare the promissory note and the guarantee, would you agree with that?
Well, everyone was CC'd on the email, so it wasn't just, so most of the time when I'm transacting with Mr. Hyder, it would also be, Mr. Dalton would also be CC'd on the emails. So there weren't many instances where I would just correspond with Mr. Hyder alone.
But would you dispute if he admitted that he gave you those instructions?
Can you clarify who he is?
Mr. Hyder
Okay, so would I dispute if Mr. Hyder,
said he gave you the instructions for the promissory note and the personal guarantee.
I would disagree only in that it doesn't include all parties involved. So Mr. Hyder, Mr. Dalton gave me the instructions on preparing the promissory note.
With respect to the Verbena Street transaction, your clients were the Daltons and D2 Property Group.
Correct.
And it's your impression that the commercial property closing and the residential property closing were all part of one transaction.
Correct.
And in that transaction, you did not represent Atlanta Plaza.
No. The seller, you mean?
Yes.
No.
So you did not represent Atlanta Beverly or the Vankmans.
No.
And you never met the Vankmans in person.
I don't believe so.
Okay. Can we pull up Exhibit 1, which has already been admitted into evidence? Ms. Kimbrough, this is an email dated July 26, 2018. It was sent at 8:38 a.m. from you to Mr. Vankman. Do you see that?
Yes. Is there a way to it's got a window in front of the exhibit. Is there a way to get rid of that?
Let me see what you're saying.
It just says stay muted or unmute.
Oh, yes, you don't want that there. Click stay muted.
Okay.
And see if that goes away.
Okay, thank you.
Excellent. Thank you for asking. Is it clear now?
Yes, it
Great.
is.
Okay, you see that email?
Yes,
And you wrote that email?
yes,
You copied Mr. Hyder,
correct,
and the Daltons were your clients in this transaction,
correct,
but you're copying Mr. Hyder and not the Daltons.
correct. We have several emails that go back and forth. Let me read the contents of the email. You'll notice your closing costs hasn't.
And there was a HUD 1
I'm
form
sorry,
attached.
if you could just give me 1 second.
I think you actually answered my question, so if you want to just keep moving.
Well-
She's free to read the exhibit.
Oh, absolutely.
Okay.
Let me know
Let's
when you're
let her
ready.
do that.
Okay, so this email was regarding reducing Mr. Hyder's fees. So I didn't find it necessary to CC Mr. Dalton regarding him receiving or not having to pay more than what the original agreement was.
Okay, thanks for that explanation. And there was a HUD 1 form attached to this email?
Yes,
And you don't know whether you ever sent this HUD 1 to the Daltons?
I'm sure I did, but if I didn't at the time of closing, that's the very first document that we go over.
Okay. Let's take a look at a exhibit that I have marked as plaintiff's exhibit 290. Permission to approach room.
Please.
Ms. Kimbrough, are you familiar with that document?
I don't really remember this document, no.
Is that your handwriting?
No,
This is not your handwriting on worksheet number 2?
no,
That's not your signature at the bottom?
no, Donnie, this looks like a D. No, that's not my signature.
Okay. I didn't know if it was or not, so I just wanted to check with you. And you don't recall seeing that document or preparing it with Mr. Hyder?
No,
If that document was produced in your file, would that help you refresh your recollection?
what do you mean in my file?
In your closing files for the Verbena Street projects,
During the due diligence, you mean?
in your file related to those projects, which was requested in this case?
I don't remember this at all. If it was provided to our office at any point in time, I don't remember it.
Okay.
And
You-
it's not my handwriting.
You can put it to the side. Thank you.
Okay.
And you testified that Mr. Hyder and Mr. Bankman made some sort of outside of closing agreement. At your deposition, you testified that.
Yes, I believe there were delinquent taxes owed on the property, if I remember. And a part of our due diligence is to ensure that all of those tax liens are satisfied at the time of closing. So we collected the delinquent taxes on the settlement statement. And I think parties had some sort of agreement that the seller would reimburse for some of those back taxes, because I think I can't remember, but I think Mr. Hyder or Mr. Dalton covered some of those delinquent taxes.
An agreement that's outside of the closing agreement is something that won't be included on the settlement statement, right?
Correct.
And that means that Mr. Hyder and Mr. Bankman were handling something outside of the closing.
Well, I don't remember who agreed to what, but yes, it means that it's handled outside of our of closing. The closing attorney has nothing to do with it. We want to ensure that the delinquent taxes are paid, and so that's what we did. Who pays them? Parties agree on who pays the delinquent taxes.
And Mr. Kendall asked you some questions about flipping. Do you remember that? And the Verbena Street project, to your knowledge, that transaction was not a flip, correct? Or do you know?
I actually don't know. I don't know if Mr. Dalton planned on buying and holding, which means renting the properties out to tenants, or if he planned on flipping the property. I'm not sure.
Okay, but to your knowledge, you don't have any evidence showing that it was a flip or was not a flip, either way.
So as the closing firm, we're not concerned with the intent of the party. So I don't have any knowledge of what he intended on doing with the property.
So that's correct. You don't have any evidence either way.
Correct.
All right, let's look at Exhibit 6. This has not been admitted into evidence. Permission to approach, Your Honor.
You and Mr. Kendall have continuing authority to approach the witness.
I have it. All right. Ms. Kimbrough, have you seen this document before?
Let me just take a look at the signature page real quick to try to refresh my memory.
Yeah, if I may, Mr. Hyde is going to excuse himself for a moment.
Okay.
To the
We'll see you soon, Mr. Hyder. If you find the air conditioning button outside the room, press it, please. We're working on that.
That was just me.
Miss Tucker, I don't specifically remember this document, but it looks like it relates to the transaction.
Is this something that you would have prepared?
No, this probably came from Sam.
Okay.
Sam is the lender's attorney,
Mr. McGuire.
Mr. McGuire.
And if Mr. McGuire prepared this document in relation to the Verbena Street project, would it have been in your file?
Say that again.
Would this document have been in your file?
Yes, at some point.
Okay. Do you know if this is a true and correct copy of this document?
I can't independently verify but it looks like it's pretty accurate.
Okay, at this time, I would move into evidence plaintiff's exhibit 6.
No objection.
6 is admitted.
All right, let's pull that up, Dak. And then I want you to drop down, see it says witnesseth, and then there's 3 paragraphs down where it says, whereas buyer has agreed to purchase. Okay, so it says buyer has agreed to purchase and acquire the entire interest of seller in Atlanta Beverly LLC consisting of 100% membership percentage, subject to the terms and conditions set forth in this agreement. And seller has agreed to convey and deliver the subject membership percentage to buyer as set forth herein. So is it your understanding based on that D2 Property Group was initially considering acquiring Atlanta Beverly LLC, the entity?
Yes, at one point in time that was discussed.
But you don't remember who specifically told you that D2 Property Group was interested in acquiring Atlanta Beverly. Is that accurate?
No, it was talked about amongst all parties.
And you don't know if you actually reviewed this specific membership interest agreement with the Daltons?
I wouldn't have at the time of closing since they didn't acquire the seller's entity. I can't remember the name of it. What is the seller's entity?
Atlanta Beverly.
Atlanta Beverly, yes.
Okay, let's drop down to Exhibit A. And you see that in Exhibit A of this document, it contemplates the sale of parcels A through I, if you just flip through the pages.
Okay.
Would you agree that that document contemplates the sale of parcels A through I?
I can't confirm off the top of my head what parcels are associated with residential versus commercial, but yes.
And this membership interest purchase agreement says that parcels A through I are owned by Atlanta Beverly, correct?
This is what the agreement says, yes.
And it's your testimony that D2 ultimately decided to go in a different direction and not acquire Atlanta Beverly, correct?
They decided not to acquire the company, yes.
Okay, let's pull up Exhibit 8, which is already in evidence. Ms. Kimbrough, this is a fax cover page dated June 6, 2016 from Mr. Vankman to you, correct?
Yes, it appears to be.
And you received this fax?
Can I see the fax?
Oh, sure, flip the page. Can you just flip through the pages since she's referring to it on the screen?
Is there not a hot button?
Oh.
Let's help her navigate. Is it in one of your many binders?
It's Plaintiff's Exhibit 8, which is in volume 1 in front of you. So see those light blue binders to the side of you?
Blue binders. You're welcome to put the white ones to the side. We'll get them back up when we need to. Blue binders are plaintiff. You want number 1. They're numbered on the front.
And it's Exhibit 1?
Exhibit 8.
Okay. So this appears to be a part of the due diligence when Mr. Dalton was considering acquiring Atlanta Beverly.
Okay, and again, that was dated June 6, 2016.
The cover letter, let me see if this is dated. I don't know when this due diligence request list was from, because I don't see a signature page, but the cover letter does state that.
And you prepared the due diligence request list that's attached to that fax?
My office did, yes.
You don't remember if you sent Exhibit 8, that due diligence list, to the Daltons?
The due diligence request list, I'm not sure. During the course of the due diligence for the acquisition, it was very brief. So I'm not sure if this was sent to the Daltons or not. I think Mr. Dalton quickly confirmed that he wasn't going to acquire the company. So the due diligence for the acquisition was stopped and the due diligence for a standard closing began.
So you don't recall whether you ever discussed it with the Daltons?
I don't recall.
Okay, as part of your due diligence for closing, you ran a title examination.
Correct.
You did not find any judgments against the property in your title examination.
No, not at the time.
Okay, I'm gonna show you what I marked as plaintiff's exhibit 11.
Yeah.
11.
11. Let me know when you're ready.
I'm ready.
All right, this is an email from you to Mr. McGuire dated July 7th, 2016, right?
Yes,
And it says title has returned on this property and it's clear.
correct.
Did you draft this email?
Yes, it appears I did. Yes,
Is it a true and correct copy of the email?
yes.
We'd move to admit plaintiff's exhibit 11 into evidence.
11 is admitted.
At a later time, you became aware that there was a $6 million judgment against Atlanta Beverly related to the Verbena Street properties.
Yes, after closing, and after the recording of our warranty deed, a judgment, an old judgment against the seller was recorded in public record.
Okay, and is that the Brandy Harris judgment?
I don't remember the name.
Okay, can we pull up exhibit 12, just the cover, which has already been admitted into evidence? Does that look familiar, Ms. Kimbrough?
Yes,
You're familiar with this judgment?
yes, kind of familiar. It wasn't a concern because it was filed after our warranty deed.
So when you were doing the initial title examination, you missed this $6 million judgment in your due diligence title examination.
No, ma'am, it wasn't recorded in public record
When was it recorded in public record?
after our warranty deed.
Okay, so if Mr. McGuire, the lawyer for Fowler Financial, testified that he had to clean up liens on the title once it became owned by Fowler Financial, this would be one of those loans he had to clean up.
So just to explain to the jury, Mr. Dalton was foreclosed on, unfortunately. And when the lender took title to the property after a proper foreclosure, Mr. McGuire then had to clear title from that point in time. So at the point in time of our closing, because in Georgia, it's a first in line state. So if you record your lien first, your lien takes precedence. If the judgment is against the seller and the seller no longer owns that property, the judgment doesn't attach to the property. Now, there are certain instances where judgments will attach to the property and to the person and will stick with the property. But at the time of our closing, this judgment wasn't a factor because it was filed after our warranty deed. So Mr. McGuire probably did have to clear any subsequent issues because that's what you do. You clear title at the time of your particular closing.
So you agree that it's extremely important as to what order the deeds are filed or recorded with the clerk,
Of course.
because that dictates the priority of who's going to have the superior title.
I would word it a little differently, but I'll just agree for the
I'm
sake
not a
of
real
it.
estate attorney,
Yes.
so I'm doing the best I can
That's
here.
no problem.
And you should feel free to word it in a way that makes you comfortable. No one's trying to put words in your mouth, but if you feel that, or there is a way to articulate it that you think is clear, you should feel free to do that.
Thank you.
Yes, please feel free. Let's talk a little bit about the settlement statements, the HUD ones. So on settlement statements, my understanding is the way it works is when you need to fill out a settlement form, you get that information from the parties about what the terms are.
Correct.
So here you got your information from Sam McGuire on behalf of Fowler Financial as one of the parties involved.
Every party involved, yes.
Right, so you also got information from Abe Bankman about what the seller would agree to.
Yes.
And you got your information from Donnie Hyder about what he said D2 would agree to.
Correct.
You don't have any written agreements that authorize you to take direction with respect to the Verbena Street transaction from somebody other than D2 Property Group.
Well, no, that's incorrect. So at the time of closing, we're sitting down for about an hour and a half and we're reviewing every single document that's to be signed. The very first document we review is that HUD 1 settlement statement.
Okay, but you don't have like a power of attorney in your file saying Mr. Hyder's acting on behalf of the D2 parties.
Well, I wouldn't need a power of attorney because Mr. Dalton appeared on his behalf physically in our office.
I understand that, but you don't have a document like that in your file.
It wouldn't have been necessary in this instance.
But you don't have that document.
Correct.
And you don't save emails at your firm either.
No, we don't save emails.
So you don't have an email in your file saying something along those lines.
Not to my knowledge.
And you don't know if every single version of these HUD-1s that are involved in this case were provided to Mr. Venkman or to Mr. Dalton.
Well, I'm sorry I don't mean to be difficult, but at the time of closing, the settlement statement is reviewed, acknowledged, and signed.
Right, so at the time of closing, and for the Daltons, they came into your office on July 13th, 2016, correct?
Mm-hmm.
They signed and viewed and reviewed with you a settlement statement, correct?
Right.
Okay, and that was the final settlement statement for them.
I can't remember. Sometimes in closings, things come up post-closing. So I can't remember in this instance if that was the instance.
And if something came up post-closing, you would review that with your clients?
It's good practice to provide a copy.
Did you do that in this case?
I can't remember.
Okay. Let's look at Exhibit 16.
Okay.
And Dak, you can pull that up. Just let me know when you're ready.
Oh, I'm ready.
Okay, so this is an email dated July 12th, 2016 from you to Mr. Dalton at 7:14 p.m.
Okay.
And you say, please, I'm sorry, before I move on, is that what that document is?
Is what it is?
Sorry, is this an email from you to John Dalton?
Yes.
Is it dated July 12th, 2016?
Yes.
And it was sent at 7:14 p.m.?
Yes.
And you believe that you did author this document?
Yes. Well, yes.
Okay. And you say, please find the attached for your review and preparation for tomorrow's closing. Do you see that?
Yes.
So you're anticipating closing the next day on July 13th.
Yes.
And your job was to advise the Daltons as to the meaning of these documents that you were sending them.
At the time of closing. It's unconventional for me to attach the closing package. But I think in this instance, there was so much back and forth with Mr. McGuire and I. So that is what appears to be the situation of, okay, we finally got the agreement finalized with the lender's attorney. Please find the attached.
So you would have discussed these documents with the Daltons at the closing on July 13th.
At the closing, yes.
And you don't know if you told Dr. Dalton or Brian Dalton that Atlanta Beverly had already sold the retail parcel to Mr. Hyder.
No, that's incorrect. So there was only one closing and it all occurred on the same day.
But you don't know if you told the Daltons that Atlanta Beverly had already sold the retail parcel to Mr. Hyder, do you?
I think I'm confused because it was always the agreement that Mr. Hyder would receive the commercial tract and Mr. Dalton would receive the apartment complex.
Do you remember giving a deposition in this case in December 2018?
Yes.
And you were under oath at that deposition, right?
Yes.
Let's pull that up. Can we go to page 135?
Is that an exhibit?
Yeah, he's gonna put it on the screen for you.
Okay.
All right, so. All right, Ms. O'Neill asked the question, did you tell him that Atlanta Beverly LLC has already sold the retail parcel to Mr. Hyder? And you ask, did I already tell him? And Ms. O'Neill says yes. And you say, I don't know if I told him. That would have come up during the course of their agreement. Did I read that correctly?
Correct, because parties agreed that Mr. Hyder would receive the commercial tract. So it wouldn't have been an express statement for me to say, something that was already agreed upon by parties.
So you don't know if before the closing, that was something that was discussed with the Daltons?
Between Mr. Dalton and I?
Yes.
No.
Okay. And you don't know if you provided the Daltons the personal guarantee that you wanted him to execute in favor of Mr. Hyder or Bristol Consulting Group?
I don't know if I provided it.
Mm-hmm.
I don't remember a specific document out of the closing package.
And I believe you testified.
Because just to clarify with the jury, a personal guarantee is a part of the entire closing package. So I can't remember if one particular document was there or not.
You testified when Mr. Kendall was asking you questions that you sent the promissory note for $1 million in favor of Mr. Hyder as part of the closing package. Do you remember that?
Well, I said I believe, and I guess I shouldn't have said that because I can't remember every email that was sent.
All right, well, let's pull up Exhibit 16 again. Let's look, can you pull out the attachments that were included on that? Okay, so it looks like we've got 8 attachments. We've got a purchase agreement, incumbency certificate, assignment of leases, rents, and profits, seller and purchaser affidavits regarding no brokers, UCC, fixture filing and financing, an unconditional guarantee, and a commercial loan agreement. Do you see this?
Yes, and just to provide context, like I stated earlier, Mr. McGuire's office and my office were going back and forth finalizing these agreements. And I felt it necessary to provide it to Mr. Dalton, but it's not the entire closing package for either mortgage. There were more documents in the first mortgage closing package as well as the second mortgage closing package.
But this was the only closing package that the Daltons received prior to coming to your office on July 13th.
Correct, because these are the set of documents that Mr. McGuire's office and I were going back and forth about.
And these documents do not contain the promissory note for $1 million, do they?
Mr. McGuire was correct. Mr. McGuire was not involved in the second mortgage at all. And
What's an incumbency certificate?
That's related to the commercial personal property.
What is it?
I'm sorry?
Well, I don't know. Well, I'm just curious. What's an incumbency certificate?
I think that's the certification for the, I can't remember, Judge.
Okay.
Yeah, I need to read the contents.
Fair enough.
But the incumbency certificate, just to clarify, it wouldn't be the promissory note.
No.
Okay. You testified that John Dalton signed the Atlanta Beverly closing package at the same time that he signed the Atlanta Plaza closing package.
Correct.
Both on July 13th.
Correct.
So Brian and John Dalton, sitting right here, came to your office on July 13th and signed the closing package for Atlanta Beverly as well as Atlanta Plaza.
Correct.
Okay, let's look at Exhibit 25. Okay. Can you pull that up, Jack? Okay. Do you see that limited warranty deed?
Yes.
Is that something that you would have prepared for this transaction?
Yes.
Did you prepare this?
My office did, yes.
And you see here that it says made the first day of June 2016 between Atlanta Plaza and Bristol Consulting Group.
Correct.
Okay. And you don't know what, if anything, Bristol Consulting Group paid to get the property that was conveyed to it in Exhibit 25.
Well, no, I don't know if any monetary money was, if any monetary means was provided.
Is it your testimony that there was some other means provided?
Well, like I was explaining earlier, Mr. Dalton and Mr. Hyder had an agreement that Mr. Hyder would receive the commercial tract, which is what this limited warranty deed is in reference to. And I just want to clarify, because you pointed out the date. whenever a person does not physically attend, whenever a party does not physically attend closing, it's called a mail away closing. So they would have executed the documents prior to the scheduled closing date, and our office would hold them in escrow.
So Mr. Hyder, on behalf of Bristol Consulting Group, would have executed this limited warranty deed prior to July 13th, when my clients were in your office executing their closing.
Incorrect. The buyer doesn't sign the limited warranty deed. It's only executed by the seller.
Did Mr. Hyder sign any documents with you prior to the closing on July 13th?
I don't think so, but I don't remember.
So the only party you're saying that saw this limited warranty deed and executed it was Mr. Vankman or Mrs. Vankman?
No, I can't confirm who saw it. I know that the sellers had already confirmed they couldn't physically attend closing. So in preparation for the mail away, our office emailed and the sellers executed the documents, I think in New York, and we provided or held those sellers' documents in escrow. So that's what this is a part of. I'm not understanding your question if that's not your question.
My question is, the Vankmans are the ones that signed this, correct?
Correct.
And you don't know whether or not my clients, the Daltons, saw this limited warranty deed at the closing on July 13th?
Oh, I'm not sure.
Okay. And the security deed included the retail parcels as security for the loan that Fowler Financial made to D2 Properties. Is that right?
Which security deed? The inferior or the superior?
This security deed, which you have testified would be the superior.
Which security deed is there an exhibit? Which security deed are you referencing?
The one that's right in front of you.
I only see a limited warranty deed.
I'm sorry. My error.
Okay. I'm just making sure I'm not confused again.
No, me too. Let's see. You did testify, though, that the legal description on one of these is inadvertent error. Can you explain that?
Yeah, so sometimes the closing offices incorrectly attach a legal description. Whenever you record a document in public record, you have to attach a legal description. The legal description specifically identifies where the property is located. And in this instance, they were identified by parcels A through I, which was confusing. And so my office inadvertently attached the wrong legal description, which is what we had to subsequently correct.
And you said you filed an affidavit of record to clarify that issue.
Correct.
That affidavit of record is not in your file for this case that you produced to us, is it?
I'm not sure.
It's not.
Okay, but it is in public record.
Okay, and on whose behalf did you file that affidavit of record?
Well, on our behalf, I guess. I mean, I don't know what you mean by that. We made an error, so it was our responsibility to correct the error.
And were you representing the Daltons in D2 when you corrected that error?
We represented D2 in the purchase of the Verbena property.
And was this affidavit of record filed after your December 2018 deposition in this case?
I can't remember when it was filed. As soon as it was brought to our attention is when we fixed it.
And you didn't produce the affidavit at your deposition, right?
I don't remember, but again, it's in public record. So the public could see the affidavit.
Okay, well, it was not publicly available to us when we took your deposition in December 2018. So do you have any reason to believe that it was filed prior to that time?
I honestly can't remember what date the affidavit was filed.
Okay. And you talked about the definition of a purchase money mortgage.
Mm-hmm.
And I looked it up real quick on my computer, as we've already established. I don't know real estate terms very well. And it has nothing to do with providing a service, does it?
I'm not sure, Ms. Tucker. The parties, Mr. Dalton and Mr. Hyder, had an agreement on what the terms of the purchase would be. And so I memorialize it according to what they stated. So on our end, what that included was a promissory note, a security deed, and the writers to the security deed to properly reflect what that agreement was.
Your Honor, I'd move to strike as non-responsive. My question was whether or not,
Well, I started it with, I'm not sure.
the purchase money mortgage includes a providing a service instead of
Okay,
funds.
I think that Ms. Kimbrough has answered the question as best she can.
Okay. Now, the jury's heard a lot of testimony related to property taxes on the Verbena Street properties in this case.
Okay.
You don't know whether you ever discussed what the seller, Mr. Vankton, was paying for property taxes with the Daltons. You don't know if you ever had that conversation.
No, that was an outside agreement. We were concerned about the taxes being paid.
Right, and when we asked you at your deposition, who pays the taxes, you said, that's not my concern.
Well, to clarify and provide context, it most definitely is our concern in that we want to ensure the taxes are paid. Now, parties can agree to sometimes the buyer paying the delinquent taxes. Sometimes the seller will pay their own delinquent taxes. It just depends on the terms of the agreement between parties.
Okay, and let's pull up Exhibit 24. Can you look at Exhibit 24 in the binder?
Yes.
So Exhibit 24 is another email, and this is from you, dated September 13th, 2016. Do you see that?
Yes.
And did you author this email?
Yes.
Okay. And you're saying you're trying to consolidate the settlement statement with both signatures on one HUD-1, right?
Right.
Okay. And this is after the July 13th closing date, right? This is
Right.
September.
Mm-hmm.
Okay, so let's go down to the HUD. Okay, can you blow it up a little bit? Okay, thank you. So here it shows the Hyder consultant fee of $457,000, right?
Yes.
Now, the taxes just generally, let me start with this. You have a ledger of disbursements in this case, correct?
Yes.
Okay. And on that ledger, you have money that came in and you have money that went out.
Correct.
But the $78,000 is not reflected on your ledger because it would have been money from whatever fee Mr. Hyder and Mr. Dalton agreed to. Is that right?
You're saying that, can you reword your question?
Yeah, so go back up to the email. And then can you scroll down one? Okay. All right, pull this document down. Thanks. Ultimately, the taxes on the property, you paid those to the Fulton Tax Commissioner. Is that correct?
Correct.
Okay, so I want to look at Exhibit 10. Okay. And you're there. So is this a copy of your receipts and disbursements ledger for D2 Property Group?
It appears to be at one point in time, yes.
Okay, and it says the closing date was on July 8th, 2016?
Yeah, I'm not sure why it says that, but that's what it says.
Is this receipts and disbursement ledger part of your file for this case?
It likely is.
Okay. Plaintiffs move to admit plaintiff's trial exhibit 10.
Kendall? It's admitted.
All right, can you put that in? Okay. This document shows your fees as $20,000. Is that correct?
It could be correct. I don't remember.
For this I'm sorry.
No,
Are you
go
still
ahead.
looking? For this transaction, you were charging by the hour?
Well, in commercial transactions, you typically charge by the percentage.
Okay,
So,
but
It
you
was at the-
testified in this case at your deposition that you were charging by the hour, excuse me.
okay.
Is that accurate?
Oh, yes.
Okay, and your hourly rate at this time was $250 an hour?
That sounds right.
So if Mr. Hyder told my client that your hourly rate was over $500 an hour, that would not be accurate.
No, not at that time.
And you never asked Mr. Hyder what your fees should be in this transaction. That wouldn't be something you would do, right?
No.
And the fees that are listed in Plaintiff's Exhibit 10, these are the only fees that your firm got related to this transaction, right?
Correct.
Any fees would be reflected in Exhibit 10.
Correct.
And you never received any legal fees for the Verbena Street properties that were paid by Mr. Hyder.
This is the only settlement statement related to both tracks.
So that's correct. You never received any legal fees directly from Mr. Hyder.
Correct.
And generally speaking, looking at that ledger, it shows that Fowler Financial provided $2 million to your trust account on July 12th, 2016. It's on the top line if you want to look at that.
Okay.
Is that correct?
I believe so. I don't remember exactly, but I believe so.
That's what this document reflects.
Yeah.
And then the disbursements show that all of the disbursements were made on July 27th. Do you see that?
Yes.
So would that be the official closing date of the Verbena Street project was July 27th?
No, not typically. This closing was a little unconventional. Sometimes you, as closing attorneys, we have to hold things in escrow until until every settlement is, or every affair is settled. So technically, the date that we're most concerned of is the date of recording.
But all the money for this transaction went out the door on July 27th.
So the check dates are going to be printed according to when they were printed. I can't remember. I think I'm more than certain the seller received a wire. So I can't confirm. Maybe if I scroll down what day the seller received their wire. Let me see.
So there's two wires listed on here. One for Atlanta Beverly is the second row on the second page.
Okay, so
it
yeah,
shows
so-
$1 million. And then there's another entry where Atlanta Beverly, it's the second to the bottom. You wired $130,000. Do you see that?
So this is an example of signing occurring on one day and dispersing occurring on another.
And then the deed for this transaction, or the deeds in this case, were not filed until September 22nd, 2016, right?
Correct.
All right, let's look at Exhibit 14, which has not been admitted into evidence yet.
Ms. Tucker, I want to take our morning break soon because it'll be lunch anyway. Is this a good time to break? Do you want to go through what this exhibit is and break after that, or what?
This is a good time to break, Your Honor.
All right, ladies and gentlemen, we're going to take about a 10-minute break as our morning break. I need to know, I forgot to apologize on behalf of the sheriff's office. It sounded like one or more of you in trying to get in today were told, oh, no jurors today. And you thought, hallelujah, but that was mistaken. We, of course, needed you. That was a byproduct of how we're handling criminal juries. In criminal cases, jury selection is in person in Assembly Hall across the street. And we can only do that on Mondays. It's the only day we get Assembly Hall. Today's a Monday. And so you guys were showing up saying, juror, juror, juror. And there were some deputies thinking, oh, no, you're not. And so they may have asked you to go home. Can you raise your hand? The sheriff's people are asking, yikes, how many times did that happen? Because they made a mistake. 1, 2, just 2 of you. Okay, thank you both for persisting and showing up and not thinking you just won the lottery. I'll let the sheriff know that it was only 2 out of 14. And they apologize insofar as that created any confusion. I appreciate you all standing firm, saying you've got a job to do here. We'll try to get you back here around 11:25. Any logistical questions? Thank you, jurors. Don't talk about the case when you go back to the jury room. Your new jury room, 8F. It has wheels?
It needs it.
Oh, you know, if it has wheels, unfortunately, yes, people have rolled off the raised step. And that may,
That would probably be me.
I was gonna say, given your entrance, would happen again. But that's why it's very hard to move the way it is. When witnesses gesticulate, they don't go flying off the witness stand. Ms. O'Neill, anything, or Ms. Tucker, before we take the break? Mr. Kendall?
No, sir.
Okay,
Except I think I may have a witness out there somewhere.
okay, we can go. You got 10 minutes to track this person down. We'll see you all at 11:22.
Yeah, but that's, she just said.
Yeah. Go ahead and make that.
Six.
It's your decision.
Yeah.
You ready to keep going? All right. Ms. Tucker, are you ready?
I'm ready.
Mr. Kendall?
Yes, I'm ready to.
So before we go. Before we go get the jurors, I need to get something on the record. A juror handed Deputy Gordon a note on one of our handy dandy note cards that the juror asked to give to me. I will read into the record what is said, and I will make this Court's Exhibit 2. It says, Attorney Tucker was being slightly aggressive and passive aggressive towards client testifying. It was very uncomfortable to watch as a juror. The way that she was questioning this Black woman was not evident in her style thus far. I know this is not a question, but I felt compelled to say something, Your Honor. Thank you for taking the time to read this. So I'm sharing this with you all because it was shared with me, and it wouldn't be appropriate if I didn't share it or make it part of the record. It will be Court's Exhibit 2. Ms. Tucker, anything you need to get in the record before we bring the jurors in?
It was not my intention to be overly aggressive. This was the first witness that I crossed in this trial. So, I thought my tone was appropriate for cross-examination. I did not mean anything, especially based on race.
You don't need to explain to me. I didn't write the note. Mr. Kendall, anything you want to get in the record?
No.
Okay. You all have heard what I heard. Let's get the jurors. Thank you. Do you have exhibit stickers that say court exhibit? If you don't, that's fine. I can probably find them back there. Oh, and Ms. Kimbrough, if you'd come back up, please. You're not done yet. No, don't sweat it. I will take care of it. I had a collection in the last courtroom. I did move them. Look at this. Court's Exhibit. Ding, ding, ding. Mr. Kendall, did you find your other witness?
Yes, I did, Your Honor.
This is the gentleman from the bank?
Yes.
Okay.
And I would like to get him before lunch because he told me he has some other obligations. He's been here since 10 o'clock.
Well, if you're short with them, maybe that'll happen. We will certainly, I don't know how much longer Ms. Kimbrough is going to be on the stand, but
I'm going to be very short.
Yay.
all right. And
In fact, extremely short.
okay.
Okay.
We're ready. Please bring him in.
Could shortcut it if that's what we're gonna do.
Okay.
That's all.
But that's not, well, no,
Okay,
I don't think so. Well,
That's fine.
let me look at that. Let me look at that. Okay, all right. Okay, let me take it. On your notes. Yes. Okay.
Thank you, Deputy Gordon. I have one more question of you all on this. I guess it would be for the two of you who were almost turned away. Was that on the Prior Street side or the Central Avenue side where you tried to come in and folks said no, ma'am? Yeah, I'm not doing a good job of describing. I think when you take this, do you take the shuttle? You park in the, you park where? Oh, in the underground?
Yes.
Okay, so well, another way to think about it is Prior Street, the traffic runs south. They're both one-way streets. So when you're walking to the courthouse down the street, if the traffic is going in your direction, that's Prior. If the traffic is coming at you, that's Central.
Oh, okay.
Central, okay, ma'am? Okay, they just need to know where they need to re-educate the crew to not try to thwart our trial. Thank you. All right. When we left off, we were in the midst of Ms. Tucker's cross-examination of Ms. Kimbrough, and we will pick up wherever that paused.
All right. And Ms. Kimbrough, I just want to note that you're an attorney and you know the difference between direct examination and cross-examination in cases, correct?
Well, yes, but I'm a transactional, so no litigating for me.
So not since law school.
Yeah, it's been a while.
And I just wanted to note that if any of my tone has come across overly harsh, it's just because I'm trying to cross-examine you and get the information out. It wasn't intended as any disrespect.
Okay.
Before we look at Exhibit 14, can we go back and look at Exhibit 16? Can you pull that up?
Yes.
Back? One of the attachments that's in Exhibit 16 is called the Assignment of Leases, Rents, and Profits. And I think it appears on page 76 of that document. Do you see that? And the first line says, this assignment of leases, rents, and profits entered into as of July 2016 by John F. Dalton, Brian M. Dalton, and D2 Property Group with the address, and then to Fowler Financial with their address. Do you see that?
Mhm.
Okay. And so the assignments of leases, rents, and profits, that was one of the documents that you did provide to the Daltons in the closing package.
Yes, which was executed by Sam McGuire's office.
Okay, thank you. Let's look at exhibit. So I want to look at exhibits 14, 23, and 26. And these are all, well, let me let you get to them.
Okay. Okay.
Okay, so are you familiar with those documents?
This looks like a version of the HUD 1 settlement statement.
And did you prepare, we're looking at exhibit 14 now?
Yes.
And did you prepare exhibit 14?
Yes.
Is it a true and correct copy of that document?
Yes, I can't confirm what version this is because we go back and forth.
There's several.
Yes.
Yes. Let's look at exhibit 23 real quick.
I'm here. Ready?
Okay. And exhibit 23, are you familiar with that document?
It looks like another version of the HUD 1 settlement statement. Yes.
And this is another document you would have prepared in this case.
Yes.
Okay. And is this a true and correct copy of that document?
Yes. And I just can't confirm what version.
And let's look at exhibit 26. Are you familiar with this document?
Yes.
What is it?
It looks like a HUD-1 settlement statement. I can't confirm what version.
Okay. And did you prepare this document?
Yes.
Is it a true and correct copy?
Yes.
Plaintiffs would move into evidence at this time. Plaintiffs exhibit 14, 23, and 26.
No objection.
Those three exhibits are admitted?
Okay. So let's go back to exhibit 14. Can you pull that up, Deck?
I'm ready.
Okay. So on line 507 of this document, can you tell us what the overdue county property taxes were listed as?
Well, again, I don't know what version this was, but this line item would have been to collect the delinquent taxes. And just to clarify, payoff statements change and expire. So if closings are postponed, it'll require us to get a new payoff amount.
I appreciate that. So that is this is just one version of the settlement.
Correct.
And if you flip to the last page, it has the last modified date and the created date. Do you see that?
Oh, yes. Uh-huh.
And that date is July 8th, 2016. Do you see that?
Yes.
Okay. So on July 8th, 2016, on the front page, line 507, that lists the overdue county property taxes on this version as approximately 127,000. Is that right?
Yes.
Okay. So now let's look at exhibit 23. Okay. And if we flip to the last page of this one, it'll have a date.
I'm here.
Okay, and this says the date created was July 26th.
Yes.
Okay. And if we look at line 507 on exhibit 23, we have overdue county property taxes of 49,000.
Yes.
And then if we look at exhibit 26, let's look at the date on that one. That one says it was created September 15th, 2016. Do you see that?
Yes.
Okay, and on that one, it also has the overdue county property taxes listed as around 49,000. Do you see that?
Yes.
Okay. And then I want to compare this exhibit 26 where it says on line 105, so now we're on the other side, the Hyder consultant fee. And this exhibit 26 says it was 457,000 approximately.
Right.
Okay, and then if we look back at exhibit 14, in that same section 105,
Right.
It's called the Hyder processing fee minus additional deposit. Do you see that?
Yes.
So it's called something different in those two documents.
Okay.
Do you know, was there a reason for that?
I can't remember.
And do you remember who gave you instructions as to what to call that?
No, it could have been just better wording for our office. Our office comes up with the descriptions typically. So it's probably just our office rewording it. I don't know.
Okay. Is that a description that you would have gotten from the parties, or is that something you would have done internally?
No, our office typically will describe what a fee is. And then if a party needs clarification, we would change it. But I think in this instance, everyone was on the same page.
Let's look at exhibit 27.
I'm here.
Okay, are you familiar with that document?
It looks like an email from me to Mr. Dalton and Mr. Hyder CC'd.
Is that a true and correct copy of that document?
Yes.
At this time, plaintiffs move plaintiff's trial exhibit 27 into evidence.
No objection.
27's admitted.
Okay. And
You can pull that up. This is an email from you to Dr. Dalton copying Mr. Hyder. Yes?
Correct.
And it says that we never received you and your brother's signatures on the updated HUD. Can you and your brother sign the attached and send back to me in the morning, to be this morning?
Okay.
Did you draft that?
Yes.
Okay, and this was in December of 2016.
Yes.
Did you ever get a signed HUD one for this transaction?
I can't remember, but I believe I did. I guess you could tell me.
All right, let's look at exhibits 46 and exhibit 25. I'd like to put those up.
Is this in book 2?
Let's see. I found my cheat sheet. So book 1 has exhibit 25 and book 2 has exhibit 46. And I can give you a copy of it if it's easier.
I'm ready.
Okay. All right, so we've got the 2 limited warranty deeds up here. And you prepared both of these?
Yes, my office did.
You've seen these documents before?
Yes.
And you recorded both of these deeds?
Yes, my office did.
And you can tell from the stamp of the clerk of the Superior Court that's on the top, sort of, yeah, there we go, that exhibit 25 on the left was filed or recorded slightly before exhibit 46. Is that right?
Yes. So whenever you send something to recording, sometimes the clerk will reject it. And so there's a time frame that we have to receive the rejection, which is USPS, snail mail. And then we have to fix the error and send it back in.
Is that what happened here?
Yes, we did receive some rejections here.
Okay. But in terms of when these deeds were filed, exhibit 25 was recorded prior to exhibit 46.
You're looking at these 2 stamps?
Yes, ma'am.
Yes.
Okay, let's pull those down and look at exhibit 3, which is already admitted into evidence.
I'm ready.
Okay, can you identify that document for us?
Let me see, let me read it. Okay.
Is that an email that you drafted?
Yes.
Okay, and the date is May 25th, 2018?
Yes.
Okay, and this is your, let's see, you respond and you're telling Mr. Vankman, upon review of the file, I have uncovered the attached seller signed documents. At the time of the transaction, the buyer requested his loan terms to be confidential, so I cannot provide the buyer's settlement statement to you. I am not authorized to disclose the buyer's loan terms or anything related to their loan. And that request would have come from one of the parties to the transaction.
Right, and it's also unconventional in this particular closing. I don't want to overcomplicate it, but because the lender is a private lender, he's not subject to the regulations called TRID, which basically TRID says there can be one settlement statement for both the buyer and the seller. But in this instance, there were 2, even though the lender was not subject to TRID.
Okay, but you would have gotten this request to keep the loan terms confidential from one of the parties in this transaction?
From one of the parties on the buyer side.
Okay, and the parties on the buyer side were the Daltons and Mr. Hyder. Would that also include the Fowler Financial?
No, not necessarily.
Okay, so the buyer in this situation is the Daltons or Mr. Hyder together as D2 parties?
Correct.
Okay, and if my clients both testified that they didn't give you this instruction, would it be fair to say that Mr. Hyder provided you this instruction?
I can't remember who gave me the instruction.
All right, and Ms. Kimbrough, I think you said that there was a new company that you write title for now, excuse me. And what's the reason that you write for a new company now?
Well, like, as you mentioned earlier, Mr. Dalton filed a $1 million claim, which, would essentially jeopardize my split with the first title company. So in an effort to maintain our same operations, I started writing for a different company.
Okay, and so part of the reason that you started writing for the new company was that because you would get a better split?
That's part of the reason, yes.
And so that basically means, and correct me if I'm wrong here, that the money that you were receiving as part of your work with titles was more with the next company.
Correct. So a part of our fee goes to the title company. And so to confirm what you said, Ms. Tucker, the new company, I get more of a split.
Thank you. The jury heard an audio clip earlier in the trial that was a telephone conversation between Mr. Hyder and Dr. Dalton. And in that audio clip, Mr. Hyder said that you had requested, and this is in the time period of 2017, to preface it. Okay, so post-closing.
Okay.
We're in the time period of 2017. Mr. Hyder said in that recorded telephone conversation that you needed to be paid $25,000 in fees for work that you did to keep the property from being foreclosed on. Is that something that you requested from Mr. Hyder?
Judge, I'm going to pose an objection here. I think it's improper for counsel to recite to the witness testimony from another witness that may or may not be accurate, may or not be what this witness knows about. So I don't think that's a proper method of asking a question of this particular witness.
I'm happy to rephrase my question, Your Honor.
Okay, I think the question is okay based on what you were asking. There could be problems with that, but not based on how you asked it. So, but let's start it all over. So poor Ms. Kimbrough is not trying to remember the long question.
Okay, so is it fair to say that you never told Mr. Hyder in 2017 that you needed to be paid $25,000 in fees for your work to keep the property from being foreclosed on?
Correct.
And is it fair to say that you never told Mr. Hyder that you needed to be paid $25,000 in fees in 2017 to get the property back after foreclosure?
Correct.
So if Mr. Hyder told my clients in July of 2017 that he needed additional money from them to pay you for fees related to this transaction, that was not money that your firm ever saw?
No, I think at one point, Mr. Dalton was attempting to refinance out of the loan. And so I don't know if that conversation was related to the refinance, which in case is a whole new closing, but not related to the closing that I had already conducted.
Right, and this loan never got refinanced, right?
No, unfortunately, they were foreclosed.
And if Mr. Hyder told my clients that he needed $15,000 to pay you for a title search and lost fees from closing on this transaction in January of 2018, so we're fast forwarded now, January of 2018, that was money that you never saw.
No.
I'm correct in that statement?
Correct.
And you never charged my clients more than $500 an hour?
No.
And you never went to counseling over the events that transpired with respect to this transaction?
Counseling?
Yeah. Did you go to counseling as a result of the events that happened in this transaction? Ms. Kimbrough, you have an Instagram account with the username of closing_attorney_Chris. Is that correct?
Yes.
And you post things there related to work on your Instagram account, among other things.
Yes.
Can you take a look at Plaintiff's Exhibit 98? And that is in Book 3, Volume 3.
Okay.
Is that a fair and accurate depiction of a photo account?
I think so.
Okay, I'd like to move Exhibit 98 into evidence.
I think that we determined that the picture in the book for 98 isn't.
It's not the same exhibit.
I'm sorry, and I apologize for the option. Ms. Kimbrough's going to be a little confused when we.
Thank you for noting that.
Okay, so
Well,
what
let me
Mr.
hand out.
Kendall is looking at is not what you're trying to admit.
I apologize for interruption. I'm trying to help move things along.
Okay,
We apparently inadvertently cropped something off from the book.
It is the same.
Okay, so the one I just handed you is the same. It just has the like a narrative from you that's been written on it.
Okay.
Is that right?
It looks the same to me.
Okay. And this post is dated July 13th, 2016.
Yes.
And that's the same day that you met with the Daltons at your office to sign the closing documents.
Is it? I can't remember.
Yes.
Okay. Yes.
And the last two sentences of that say, I'm also selfishly toasting to a multi-million-dollar deal I closed today that has been the biggest deal for Kimbrough Swift yet. Did I read that correctly? Can we put that up?
well, it's not in evidence yet.
Oh, I'm sorry.
That's
I thought
okay.
I did move into evidence. We would seek to move plaintiff's exhibit 98 into evidence.
I don't have an objection.
It's admitted.
Okay, so the last two sentences is what I'm looking at there. I'm also selfishly toasting to a multi-million-dollar deal I closed today that has been the biggest deal for Kimbrough Swift yet. This deal challenged me professionally and emotionally. Do you see that?
Yes.
Can you explain to the jury how it challenged you professionally and emotionally?
There was a lot of moving parts, and it was an unusual deal structure, and there was a lot of back and forth with the seller side and the buyer, which was trying.
Thank you.
Mhm.
You can take that down. And Ms. Kimbrough, you know that Mr. Donnie Hyder is the owner or principal of Bristol Consulting Group.
Yes.
And you estimate you've done at least 10 real estate transactions involving Mr. Hyder.
I believe. I can't remember how many, but yes, unfortunately, I wish I could remember them all.
And some of that work was also involving Bristol Consulting Group, his business.
Yeah, I believe at certain point he had two different entities. So I can't remember which entities he would take title under or transact under, but yes.
And you also have a social relationship with Mr. Hyder outside of the real estate work?
Can you define social?
You might go out to dinner with him or members of his family.
I've been at a client dinner, a client lunch, and I've also seen Mr. Hyder at a political fundraiser.
Okay. And do you socialize with any of his children?
No.
Okay, let's take a look at Plaintiff's Exhibit 99 in the book.
Oh, I don't have oh, here we go.
I can bring you a copy if it's not in there.
Okay.
Okay. Do you recognize that photo?
Yes. It's one of our closing pictures that we take at the office to memorialize a transaction. It's just very embarrassing to see my face this big.
I'm sorry, and I totally understand.
Be strong because it may go up on a screen in just a moment. You
Mentally
ready?
prepare yourself. Okay, is this a fair and accurate representation of this picture?
Yes.
Okay, at this time, we'd move Plaintiff's Exhibit 99 into evidence.
It's admitted.
Okay, can you put that picture up on the big screen? All right. And Miss Kimbrough, that's a photograph of you with Mr. Hyder, correct?
Yes.
And you just said it's from a closing transaction.
Correct.
And the date of the closing, was that what's on the bottom, April 13th, 2018?
No, not necessarily. This is my personal IG Instagram page, so it could have been after.
Okay,
It's not necessarily posted in real time.
gotcha. And what does thanks no IGD for closing with us mean?
Well, I didn't know Mr. Hyder's Instagram page, so I couldn't tag him.
Okay, so that's no Instagram, Donnie.
Correct.
Okay, gotcha, for closing with us. Okay, we can take that down. And then let's take a look at plaintiff's exhibit 100. Do you recognize that document?
Yes.
Is that a photograph also from your Instagram?
Yes. Looks like I'm memorializing another closing.
Is it a fair and accurate representation?
Yes.
Okay, we would move plaintiff's exhibit 100 into evidence.
Admitted.
Okay, let's put that up on the screen. And again, this is memorializing another closing.
Yes.
All right. Let's take that down and can we look at plaintiff's exhibit 101?
I'm here.
Do you recognize that document?
Yes.
What is it?
Another picture from a closing.
Is it fair and accurate?
Yes.
Plaintiff's move into evidence, plaintiff's trial exhibit 101.
No objection.
It's admitted.
Okay, and is that a picture of, there's a few folks in this picture, but is Mr. Hyder in this picture?
Yes.
And are you in this picture?
Yes.
Okay, and the date on the bottom of this picture is April 26, 2019, is that right?
Correct, but I don't post in real time, so I can't confirm that that's when the picture was taken.
Understood.
Would it be months apart or days apart?
It could be months. Yeah, there's no rhyme or reason. So the objective in owning a small business is to promote yourself. So in order to promote my firm, I post all closing, well, not all, but a lot of closing pictures.
So could I get in your Instagram account?
If you refinance or close with us.
All right, I'll keep that in mind.
So would 2019, the year, would it be fair to say that you did a closing with Mr. Hyder in 2019?
Did I? I could have. I can't remember.
Okay. And this date doesn't give you any help as to when you posted that?
No.
Okay. And are you still doing business with Mr. Hyder?
We don't have any, our office doesn't have any contracts with Mr. Hyder or Mr. Dalton.
Okay. Thank you very much. That's all the questions that I have.
Thank you.
Mr. Kendall, any follow-up from Ms. Kimbrough?
Just briefly, Ms. Kimbrough, I want you to turn over to plaintiff's exhibit number 12.
Okay. I'm here.
Okay, that document, let me get to it right quick. I'm sorry. Book one. You identified that document and talked about it a little bit on cross-examination. Again, just to refresh the members of the jury, what is that particular document?
This was a complaint filed against the seller at the time, Vacnim, and this is the FIFA related to that complaint.
Okay. Now, do you see the wording that's like north and south stamp?
Yes.
What does that represent?
That represents when the FIFA attaches or could potentially attach to a property. So that gives the priority in which a lien would be recognized, if that makes sense.
Okay. Now look over at that stamp and tell me what date this judgment was filed.
October 11th, 2016.
Okay. Now look at the limited warranty deeds that you drafted in this case at plaintiff's exhibits number 25 and 46.
Okay, September 22nd, 2016.
Is that on both of them? On 25 and 46?
Yes,
Okay. So September the 22nd, 2016 is prior to October the 11th of 2016, is that right?
correct.
So this particular judgment that was filed on October the 11th, 2016 against Atlanta Beverly, Atlanta Plaza, Abe Vackman, et cetera, would not have affected what you did in terms of a priority lien on the title. Is that correct?
Correct.
And I mean a priority lien on the Atlanta Beverly transaction and the Atlanta Plaza transaction.
Correct.
Okay. So are you familiar with a complaint that was filed against you by Mr. Sam McGuire?
Yes, many complaints.
Many complaints. Okay. Was one of his complaints concerning this particular judgment?
I believe so. This and the release of the tax FIFAs. So just to explain to the jury, whenever there's a FIFA against the property, the lien can be satisfied, but it's up to the creditor, which would be the tax commissioner in this instance, to file a subsequent release of that lien. So it can still appear in public record, but not be released.
You should probably explain what a FIFA is.
That was my
Okay,
next
so a FIFA is just a lien. Let's just say lien to keep it simple.
Okay. Now, I want to ask you about the questions Ms. Tucker asked you concerning your title insurance carrier, the one that I think is American Title, is that right?
First American.
First American Title. Was that company the company that Mr. McGuire filed the complaints against?
Yes.
And what were the subject of his complaints?
Mr. McGuire essentially wanted me to follow up with the tax commissioner post-closing. It was my understanding that he was the closing attorney on a subsequent transaction concerning the same property. And it's industry standard for the next closing attorney to request the release from the tax commissioner. Mr. McGuire wanted me to do that for him.
Okay, so did you consider his complaints to be unfounded?
Yes.
Did his complaints cause you any problems with First American Title?
Yes.
And what kind of problems were those?
Well, a disagreement that ultimately ended up in me writing for another company.
Okay, so were his complaints an impediment to your ongoing relationship with First American Title?
A part of it, yes.
That's all I have.
Ms. Tucker, anything else?
No further questions, Your Honor.
Ladies and gentlemen, if you have any questions for this witness, now is the time to write them down. Excuse me, and Deputy Gordon will collect them. Thank you, sir. All right. Ms. Tucker? Kendall? I see that. Swap. Right. Things. That's the question for this. Correct. I agree. Just wanted to. Oh, that's good. Okay. Thank you.
Ms. Kimbrough, a few more questions. Did you prepare, is a HUD the same as HUD 1?
Yes.
Okay. Did you prepare a HUD 1 for Mr. Hyder on his purchase of what we've been calling the commercial parcels?
So all of the fees are on one settlement statement. So there weren't any separate settlement statements for the commercial track and for the residential. It was all part of one agreement.
So one HUD one for all the Verbena Street parcels.
Correct.
Why wouldn't there be a separate HUD one because someone different was getting, based on your understanding of the transaction, someone not D2 was getting two of the parcels?
Because there weren't any separate fees associated with the second commercial track.
When you say fees, your fees or any fees at all? Okay. So like if there was a title insurance fee, it was to all the parcels combined.
Correct, but there wasn't a lender's title policy that was purchased for the commercial track.
Just making up an example.
Okay.
Okay. Did you provide two different HUD ones to the Vacnins, one for the commercial parcels and one for the residential parcels?
No,
Same reason?
same reason.
Have you ever asked clients about the business relationship side deal is the wrong term, but whatever the negotiations were between the parties to a real estate deal at or before the closing?
Do I ever ask parties about the real estate deal before or at closing?
Yeah, and I don't mean so you understand you're selling this for $1 million, but you have received questions about well, what were the negotiations between the Vacnins and Mr. Hyder or D2? And so the question I'm asking is, do you typically inquire of the parties to the closing? Hey, I need to understand who's selling what to whom. Why are there three parties here? It's one piece of real estate.
So, like I was trying to, and probably didn't do a great job of explaining before, is this deal was unusual in that a commercial track was going to Mr. Hyder and the residential track was going to Mr. Dalton. So in my other closing experiences, it is unusual. It wasn't a conversation because that was the agreement the entire course of the due diligence. So I get what the agreement is between all parties, and then I memorialize whatever those parties agreed upon. Does that answer the question?
That's your answer.
Okay.
Do you ever move forward with your line of work, closing on a real estate deal, if a client has not secured funding?
I think what they're asking is it possible to close before we received the buyer's funds? Is that the question?
The question is, do you ask clients if they have secured funding before you accept their work?
No, that would be part of the lender's due diligence. So at no point does our office underwrite the buyer's credibility for financial stability. That's solely done by the lender.
When an affidavit of record is filed, do you have an obligation to let everyone who's affected by the affidavit of record know that it's being filed, that there was some mistake and here's the correction?
I think it's good practice just in general to notify parties when anything is recorded of record. I think it's good practice.
When you completed your work in connection with the Verbena closing, did either of the Daltons reach out to you to say, hey, great job? Words to that effect?
Yeah, immediately after closing, everyone was on the same page. There was no question about anything. Mr. Dalton never at any point said, hey, where are the keys to those commercial tracks, or where are those lease agreements for any tenants in the commercial track? Because the commercial track was still up and running. So it wasn't until Mr. Hyder filed a lawsuit against Mr. Dalton that all of this erupted.
Did either of the Daltons ask you any questions about any of the documents you gave them in person or sent them via email or FedEx to sign?
Did they ask any questions about it?
Like, what is this? I don't know what it is.
No.
Did they ever challenge any of the fees that went along with the work that you did?
No.
Okay. Mr. Kendall, do you have any follow-up based on the exchange that Ms. Kimbrough and I had?
I do not.
Ms. Tucker?
No, Your Honor.
Ms. Kimbrough, thank you so much for your time. Is Ms. Kimbrough excused?
Yes, she is.
You're free to go. So, Mr. Kendall, we probably got about 20 minutes or so before we break for lunch, if we don't do that sooner. You have a witness you think you can fit into that
I do.
20 minutes?
Probably 10 or less.
Okay.
On my side.
Okay. Call your next witness, please.
Mr. George Andrews.
Now, he may not beam in the room. You may need to send someone to get him.
He's out and sitting in the hallway.
All right. Good afternoon, sir. If you wouldn't mind coming on up to the witness stand. Right up here. Thank you so much. Just got to navigate a few of the pieces of equipment. If you'd stand right next to the witness stand, Deputy Gordon's going to swear you in. We'll get started.
Yes.
And you should feel free to close those binders. They are for,
Cut this thing off.
they have a way of doing that right when you get into court.
Oh, this thing ain't working, y'all.
It's all right.
Let's cut it off.
Got it?
I think that's it. Yeah.
All right. You should feel free to close those binders so you've got a little real estate for you.
Okay.
And once you get a seat, if you would state your name for the record.
Okay.
Thank you.
My name is George G. Andrews.
Mr. Andrews, I want to ask you a couple of questions. Currently, how are you employed?
I am running the Unity National Bank operations here in Atlanta, Georgia.
Okay,
Banker.
so what is your official title there at Unity National Bank?
I'm responsible for opening and operating banks for Unity. And my role is institutions development.
Okay. How long have you been in the banking business?
I've been in the banking business since 1974.
1974, did you say?
Yes, over 40 years.
Okay. What financial institutions have you been associated with?
I started my banking career with SunTrust Banks, which was formerly Trust Company Bank, and later started my own bank by the name of Capital City Bank and Trust Company. And I am presently employed with Unity National Bank.
Okay. I want to draw your attention to a transaction that was ongoing back in the year 2016 involving Mr. Donnie Hyder and a company called D2 Property Group LLC. Do you recall being involved in some discussions about that project?
Yes, I do.
Okay, tell me what it is that you recall about that particular project out on Verbena Street, which we have colloquially termed the Verbena Street properties.
Sure. Mr. Heidemann gave me
Mr. Hyder?
Mr. Hyder, I'm sorry. Referred a gentleman to me that was interested in financing, refinancing project out there. And I received financial information on the project in that regard.
Okay, who sent you the financial information?
I don't remember who sent me the financial information, but I received the financial information on the project, and we began to look at it in terms of processing.
Okay, did you have any conversations with Mr. John Dalton, who's seated over here to my right, who owns D2 property regarding that particular project?
Yes, I did.
Okay. Do you recall what the subject matter of that conversation was?
Well, the subject matter of the conversation centered around the project itself in terms of the cash flow, how it would be renovated, and then the expected income from the project after it was renovated.
Okay. Did you have any discussion with Mr. Dalton concerning retail tracts versus apartments?
Absolutely. I wanted to understand the nature of the retail tract and the residential project so that I can understand exactly how the cash flow would be realized and how the loan would be serviced in the event that there were difficulties in either the retail side or the residential side. So the conversation centered around how each component would work with each other and who owned what as it related to that component.
Was there any discussion about the fact that D2 was not structured in the transaction to own the retail tracts?
Yes, it was.
Tell us about that, please.
Well, I wanted to know why this project carved out the retail portion of it, because the retail portion obviously has a lot of significant strength in and of itself. And the answer was that the retail portion was separate from the residential portion, and that the residential portion could stand on its own in terms of any type of financing that they would be seeking.
So let me ask you this. You say you had this conversation with Mr.
Yes.
Dalton, right?
Mm-hmm.
Did you get the impression, and tell me if you did you get the impression that Mr. Dalton understood that he was not to own the retail portion of this project?
Yeah, I actually asked the question, do you understand the nature of this deal, that the retail section is separate? And from a lending perspective, it weakens the project. And he said he did understand that the retail is separate from the residential part of it, because it was very important to us that everybody understood the transaction as related to retail and the residential component.
Okay, when you had this conversation with Mr. Dalton, can you give us an estimate of how long this conversation took over the phone?
Conversation probably lasted anywhere from, I don't know, maybe 10 to 12 minutes, something of that nature.
Okay, and you covered these subjects in that 10 to 12 minutes?
I covered the subject in that 10 to 12 minutes.
That's all I have this week.
Ms. Tucker?
Thank you for being with us here today.
Thank you.
My name is Sarah Tucker. I represent the plaintiffs.
Okay.
Just one quick question for you. When was this conversation? When did it take place?
I don't remember the actual date, but it was sometimes during 16 years.
It was
12.
in
Yeah,
2016?
2016, I think.
Did you give an affidavit in this case, Mr. Andrews?
Did I have an affidavit?
Did you provide one?
No, I didn't.
You did not provide an
Right.
affidavit in this
Mhm.
case? Right. Can I see Exhibit 40? And I just wanted to provide this to refresh your recollection, Mr. Andrews. Take a second to review that and just let me know when you're ready.
Okay, I did sign this.
Okay, and all I wanted to know was when this conversation took place, and after reviewing that document, did that refresh your recollection?
Well, again, I remember having a conversation. I thought it was in 17, but here it says, I thought it was in 16, but here it says in 17, so.
Okay, so your affidavit that you provided in 2018 says that
Yeah,
the conversation happened in May of
Yeah.
2017. Is that right?
yeah, I would yield to that. Mhm.
Okay, thank you. That's all the questions that I have.
Mr. Kendall?
Yes, are we tendering that?
Yeah, just to say, let's admit that document.
Okay,
Do we want to admit plaintiffs 4-0?
Exhibits, plaintiff's exhibit 40 into evidence.
No
I
objection?
have no objection.
It's admitted.
Mr. Andrews, can you read that affidavit? It's very short.
Okay,
It's a bunch of paragraphs. Is there one in particular you want them to read, or you want them to read everything?
I kind of want to read everything.
okay.
Eating into your 20 minutes.
This is it.
Okay.
Can you just read it out loud? Read it
Okay.
out loud.
I worked in the banking and financial.
We're speaking to the microphone so
Okay,
everybody can hear.
I have worked in the banking and finance industry in the state of Georgia for over 20 years and have played a vital role in helping both individuals and companies obtain financing for various real estate transactions. In order to effectively help clients search for and obtain financing to fit their specific needs, it is imperative that I have a very clear and concise understanding of what they are seeking financing for. This includes obtaining both general information and or more specific information such as legal description of properties in question and the terms of any recently concluded or pending real estate transaction which the funds obtained may be used. In or around May 20th, 17, I spoke with a local doctor that had recently purchased an apartment complex on Vermina Street in Atlanta, Georgia. In my discussion with the doctor, I asked several questions about the circumstances surrounding the purchase. I specifically discussed new market tax credits with him to ensure that he was aware that he would not benefit from the credit because he had only purchased the apartment and not retail commercial property. I informed him that in lieu of that information, I had to question why he went through with the purchase initially. The doctor went on to explain that he thought he would be successful with just the apartments at the time of the purchase, and the feelings had not changed. He expressed more than once that he has always known that he has no right to or interest in the retail property, and that he was seeking finances for the apartment complex only.
Thank you, sir. That's all I have.
All right. May your witness step down.
Yes, he can be excused as well.
Mr. Andrews, thank you so much for your
Thank
time. You're free to go. So jurors, we're going to break for lunch now. It is just before 12:30. I'm going to ask you to be back as close to 1:30 as you can make it. We will endeavor to get you from 8F back to 8D at 1:30 to have Mr. Kendall know what's next with the defense presentation. You're free to go to lunch wherever you want. Just make sure it's not more than half an hour walk away because you have to walk back and be back by 1:30. Any logistical questions? Seeing none, don't talk about the case while you're having lunch, and please be back to 8F by 1:30. Thank you so much.
All right, you all can be seated. Mr. Kendall, by my math, you plan to call, if you're going to, Mr. Hyder as your next witness.
If I'm going to, yes.
Right, if you're going to, but that would be your final witness if you call Mr. Hyder.
That's correct.
Okay. At this point, Ms. O'Neill, do you envision any rebuttal testimony?
Undecided, but if I do it, it'll be short.
Okay, well, you have an hour to work through that. And we'll see what's happening. Please be back here by 1:30, and we will see what's next from Mr. Kendall. Have a good lunch break.
Thank you, sir.
Say it to 1:30.
1:30.
Yeah. Was it 80-27 minute? 17. Second, he said,
left, so I guess I can't do that. Did you get the tape? Seriously?
Sure. She tagged it to the deed
That's interesting, did you hear that? They can't find an affidavit here.
it's nothing to tag to the
That's
deed.
amazing. Will you go tell John that, because he should tell Lumen to go look right now. Yeah. Hey, John?
And what's there? Yes. Sanitation.
Who did it? Whoever burned it.
Circulation to.
Was it that's really true?
She just, you know, she was doing all the stuff.
See, this is the problem. It chooses the boss.
Yeah. Wi-Fi thing.
Not this thing. Someone changed. needs, and I need it done today. Fantastic.
And the parcel we're talking about is 46, right?
Mm-hmm. Well, I guess I didn't change it. Yeah.
Nothing closing, tonight. I'm working for your afternoon first.
What about Russians?
I don't know, not yet. Let's see if that's some cash.
What's that?
Last time, the phone back.
Yeah, that's different than one different, right?
This one was not different.
We have to.
I'll have to go back and look at the Friday. Yes.
I don't have the ability to pull up from sitting room. Sure, I'm just gonna grab it. I'm not gonna find one, it's not right, I can do it tonight.
Whatever you want. Person take your
See, it keeps kicking me off. And I think it's because my microphone keeps kicking. M1, M21.
I can go with education.
It's very good.
Some of them, I don't.
Do you have a snack or? Is it spring?
Yes. Yes.
Now maybe it's time to do it.
I was thinking so. Two or seven. Two or seven. Now we're going to.
Yes.
Right.
What time y'all start makeup? Oh, okay, so they'll come back. We started making 1:30 anyway.
Where's the other ones? Where's the other ones?
I'll give you.
What's this?
Oh, that's 176.
This is. Where's this one?
Is it a non?
I did.
I know, is it?
Would have been one that would have been in the folder. On the website.
It seems not too.
It's not too late. Are you ready to, do you want to wait for the court to do the tax exchange?
Oh, we can do it.
Look at them, we can't.
We can do it now. Close your eyes. No. I'm not listening to
We got
Okay, great. About time. You all can be seated. You ready? Mr. Kendall, you ready for the jury?
Yes, sir.
Have you decided whether you are resting or calling another witness?
We're gonna rest.
Okay.
We're gonna rest.
Ms. O'Neill, based on that announcement, are you calling any rebuttal witnesses?
You're not.
Okay, so there won't be you've rested, you're staying rested.
I'm saying, right, so I think then what we have is the instruction conference, the remaining issues on the fees. And I'm looking, we just got the tax returns. So, we're looking at that, but I guess if Mr. Hyder's not being honest, and it doesn't matter.
Don't need them. I am about 2/3, a little more of the way through the draft charge, and then I can get it to you all. But that is something we'll need to talk about before you give your closings, so you know what's going to be in there and what's not.
Can we do closings in the morning?
We have like 3.5 hours.
No, I needed to work on my closing.
Ms. O'Neill?
I would prefer to do it tomorrow, but if we have to do it today, we can. I'd like to know the instructions
Yeah.
specifically before, and particularly, there's a couple of things when we submitted today, some other things I think we need to talk about.
Yes, there are a number of things we need to talk about. Why don't we do this? We'll bring the jurors in. You'll make your announcement. I'll let them know they can go home for the day because we have a lot we need to work on. It will take a while for me to finish the charges. I want you to have a chance to read them. We'll have our charge conference. Ideally, we'll be done before 5. We'll be done after however long it takes to get through the charge conference and talk about attorney's fees. And then can we start at 9 tomorrow?
Yeah.
Okay. We're back on schedule, given the decision not to call Mr. Hyder. So I'm comfortable sending the jurors home early today. All right. So that plan works for you, Mr. Kendall.
The plan works for me well.
Well,
I'd like to-
I don't like that plan anymore then.
Well,
Now I gotta change my closing now that Mr. Ryder's not gonna testify, but I do need to change, I'd like to change the tax information back.
Okay, I'm gonna just hold on to everything now. Let's bring the jurors in, send them home, and then I'll be out of your hair for a while, out of your space for a while, to finish up the jury charge. And then I'll get a draft copy to both sides. You can have a little time to read it over, then we'll have a charge conference. So let's go get the jurors. We'll work through this next phase and go from there.
okay.
Oh,
That's what I suggested in the beginning, remember? Forget about the taxes.
But you taught me a new trick,
What's that?
the notice to produce, I'll be using that in my next trial.
Let me tell you how much judges love something like that.
I learned a new trick,
What was the new trick again?
the notice to produce.
Oh,
I'm sure I've tried to make trials of you, but I've tried 50 jury trials all over the country. And that has never happened to me before. Yeah, so you taught me a new trick. I'm sorry, ma'am, I can't hear you. May I ask the judge a question? So charge conference typically, and I guess, Mr. Kendall, typically the way I've done charge conferences is we have the conference, we do whatever, we know what we're gonna get, then we go back on the record to make the objections.
Yeah.
Is that how you do them?
I'll work with you all on how we do them. We'll have our charge conference. You can decide whether you want it taken down or not, but you'll know at the end of the charge conference, this is what's in and what's not. So we could, tomorrow morning, just before 9, say, do you want to get your exceptions on the record? And you could say, I'm disappointed you didn't give the charge on Trover and whatever so I don't have a problem with that. What I won't like is if you guys come in tomorrow morning saying, I'm old, I don't remember what you ruled. If it's not on record, I may not remember either. So it'll be up to you guys to take notes, but that works for me.
we're trying to let the court go. Yeah, we can do it in the morning. We can put objections on the record in the morning.
So unless the judge wants you, you probably do need to stay for the release of the jury because that's the formal meeting, but then. One second, Your Honor. We're good.
See, I'm waiting for you. So, I'm trying to you. Get ready. Yeah, I am. And then my two grandkids came. Another time people were forever.
It's good to double check because you never know when something comes up. Like, wow, what are you bringing them in for? You told me to. Thank you, Deputy. Welcome back, ladies and gentlemen. Hope you had a good lunch. Mr. Kendall, if you'd call your next witness.
Judge, we would at this time rest our case.
Okay. The defendants are resting their case. Any rebuttal, Ms. O'Neill?
Please do not have a vote.
All right. Ladies and gentlemen, the evidence in this case is closed. You have now heard from the witnesses who are going to testify, and a lot of exhibits have been admitted, but whatever's been admitted, that's it. We're done with the evidentiary piece. We're going to end for today. You're going to end for today. In a little bit, you're going to leave. What is next is a lengthy, emphasis on lengthy, conference that I have with the lawyers about the law that I'll give you all after you hear closing arguments. Both sides have submitted proposed jury charges. I've been looking at those. I need to finish looking at them, and then the lawyers and I need to talk about what's the appropriate law to share with you when it's my turn to give the final jury charge. We probably wouldn't finish with that until 3:30 or so. So you'd be back in 8F until 3:30. And we might not finish with closings if we started at 3:45 by 5 o'clock. And so you'd be partway through closings, you'd go home, and it would be very disjointed. It would be more disjointed than if we let the closings occur all in one block. So this is a little unexpected. Welcome to life as a juror. But I'm going to release you for today in just a moment. And we're going to pick up, we're now ahead of schedule. So we're going to pick up tomorrow morning at 9 a.m. And when you are brought in here from 8F, so go to 8F tomorrow morning, and there's no criminal jury selection tomorrow, so no one should try to bar the door, but you all have figured out how to get in, so come on in. You'll come in here and you will hear the closing arguments from plaintiff's counsel and defendant's counsel. When that's done, we get a little break. And then I will give you the law that you have to apply to what you find the facts to be based on your consideration of the evidence. And when I am quiet, you'll go back to 8F and you'll be able to start your deliberations. The fact that the evidence is closed makes it all the more important that you not discuss this case with folks away from here, because anything more you get about this case would be inappropriate. You've now heard all the evidence. You'll decide what that means and what you think of it when you deliberate as a group in 8F only after you've heard closing arguments. And just as importantly, you've heard from me what the law is. It's kind of hard to make up your mind right now because you don't know what it is that the plaintiffs had to prove as part of their burden of proof. All that will be revealed, hopefully, tomorrow when we talk to you about those things. So early end, go do fun things. I will not call your employers to say, hey, it's 2 and they're done. So you should see them at work. And we'll see you back here as close to 9 a.m. I know we started at 9:30 today, 9 a.m. tomorrow. Any questions about any of that? Thank you for rolling with this. We've zigged when we thought we might zag, but we'll be ready for you tomorrow morning. If you'll go with Deputy Gordon, you can get all your stuff from 8F and then report to 8F tomorrow morning. Thanks so much. All right, you all can be seated. So on the tax return front, have the parties unexchanged documents? So in effect, no one's sitting with someone else's tax returns right now?
That's correct.
That's correct.
Okay, cross that off my list. We do need to talk about attorney's fees. If you all submitted anything to Ms. Niles, I haven't seen that yet. Did you get anything? Okay. Do you want to talk about that when we're having our charge conference, or do you want to talk about that now before I retreat to chambers to wrap up my work on the draft charge?
I'd like to talk about it now for two reasons. One is I think it needs to be on the record,
Mhm.
and we're gonna let the reporter go to the charge conference off the record, and do exceptions tomorrow morning. Also, I'm gonna do it, this part, and I'm gonna ask Ms. Tucker to do the charge.
Someone's pulling rank. Okay.
Yeah, Ms. Tucker.
Mr. Kendall, does that schedule work for you?
That works for me.
Okay. So Ms. O'Neill, talk to me about, let me frame it as I understand it. There is evidence in the record about attorney's fees. There's all sorts of testimony, and there is maybe plaintiff's 281. I didn't rule on its admissibility because there were some concerns raised, and so we agreed to defer ruling on it. But I believe when Brian Dalton was on the stand, Mr. Kendall asked Brian Dalton, well, where are these legal fees, these bills? And magically, this giant red well appeared on the witness stand for Brian Dalton, and it had the bills from Womble Bond Dickinson in it. And I think you, Ms. O'Neill, tried to admit plaintiff's 281. There was an objection, and we tabled that. The deeper issue is what is the standard of proof for attorney's fees in this tort context we're in? We're not in a 9-15-14. As I've been thinking through it, if this had been a situation where the Daltons slipped and fell at Mr. Hyder's shop in the Verbena Street area, and were suing, and it was my knee got hurt, I don't know that there is a requirement that the orthopedic surgeon's bills for the knee have to be proven to be reasonable. There's proof. Hey, this is what I paid Resurgence Orthopedics to get my knee fixed. And that is sufficient. The doctor doesn't come in to say, I've been practicing for 20 years and what I billed for this ACL surgery is reasonable in the Atlanta market. The bill is what the bill is. It can be attacked, but it doesn't have to be supported beyond the bill. Or if the victim remembers, yeah, I paid the doctors at Resurgence $212,000 for surgery and related treatment. So that's what we need to work through. Having said that, what I'm familiar with, I don't know that the law requires it, but I'm familiar with these lodestars. That was Mr. Kendall's term, where lawyers in lots of different settings, and it's not just 9-15-14. It's often when I'm dealing with default judgments for homeowners association cases, and the lawyer comes in and says, this person owed $300 a quarter on homeowners assessments, and here's the ledger, and there's a business records exception, and they come in, and then the lawyer says, I'm here to tell you, I charge $175 an hour. That's standard for my line of work. I've been doing this for 4 years. And I hear all those points ticked off that are precisely the points that Mr. Kendall described, but it's in a setting where there's no one else in the room to say it's reasonable or not reasonable. So
That is where we are, Your Honor, and I agree with Mr. Kendall that in a 9-15-14 claim, that I would need to stand up and testify, or somebody would have to testify. Specifically did not make a 9-15-14 claim. We simply asked for them as part of the damages in the case in relation to the fact that there's fraud and bad faith. And well, yes, the American system is generally that each party pays its own fees. The fact is that under Georgia law, if you have a fraud claim, you can recover attorney's fees. And I believe on this record, this has been met, but if the court feels that it has not, then it's just dismissed. So that's that ruling.
When you say on a fraud claim, are you contending that a fraud claim is a special species of tort? Or could it also have been just a negligence claim, or is there something special about fraud where you think the way in which attorney's fees can be demonstrated is different?
I think under 13.611, which is the exception to the, what I call the American rule, that each party bears their own costs. You have to have, I believe the term that they use is bad faith, which is certainly an element associated with the fraud claim. So you could make a specific 13.611 claim, which we did not do. But I believe that having pled it this way, the reasonableness can be proved or attempted to be proved in the manner in which we've done it. But again, if the court accepts Mr. Kendall's argument that you have to have a lawyer stand up here and do that, we'll accept that ruling.
Did you find case law that was not supportive of your position?
I didn't find case law that looked at our precise question. There's tons of case law that talks about reasonableness. And there's a lot of case law that says, to be frank, there's some case law that says there is nothing to indicate reasonableness, but if the appellate courts don't say if the I believe the question to this court is sufficiency, not absence.
Okay.
And the question is, under a record like this, where you have, as you said, we ticked off the points, is that sufficient to prove reasonableness, or as a matter of law, do you need more?
Do you object? You can think about it overnight. Would you object to a verdict form that broke out damages so that attorney's fees was a separate number, so that if the jurors end up saying a number other than zero overall, that they would be asked how much is not attorney's fee? I don't know what the wording would be, but importantly, there would be an item for attorney's fees so that if the decision to let attorney's fees go to the jury is ultimately decided to be a bad decision by a higher court, the fix could be something short of you have to do the trial all over again. It could be a simple remand saying you got the wrong number.
I thought about that over the weekend, Your Honor, and we would accept that. I sort of was envisioning a verdict form that would say, if you find what damages, if any, to reward the plaintiffs, and it would be damages sort of parent other than attorney's fees.
Okay.
For that very reason.
All right.
Because I will state on the record that we do not want to.
Okay. Mr. Kendall.
Judge, I pretty much stand on what I initially said when this issue first arose. I don't think that the issue should go to the jury. I don't think there's any evidence in the record regarding the reasonableness of any rates that are in that big red well with their bills in it, nor is there any testimony regarding the reasonableness of the time and effort that those bills represent in terms of this litigation. So on those 2 points, I think the law is clear that there has to be sufficient evidence of both the quantity and of the time spent, as well as the reasonableness of the rates that are being charged. There's no evidence on either of those 2 issues, which means that that particular element of their damage claim has been insufficiently supported, and it should not go to the jury.
Okay.
And I would just note that the records were very clear. I'm first to get the number.
Sure.
It doesn't have a sticker on it. If the plaintiff's exhibit with the bills is not admitted, I agree with Mr. Kendall that we have not met the requirement for hours, the number of hours. Because that admission is an open question. We move to admit it, there was an objection, we tabled it.
Right.
If it's not admitted, I agree with Mr. Kendall, we have not met the option for
Okay.
requirement to show the hours. That's the exhibit that doesn't,
All right.
but I can't remember the exhibit number.
It's 281. On the heels of hearing that concession, Mr. Kendall, I assume you still object to the admission of plaintiff's 281. Tell me why 281 should not be admitted.
Well, I asked the witness on cross, Mr. Brian Dalton, where are the bills? And then somebody brought up a red rail during my cross-examination, said, here are the bills. I didn't ask, I just asked him, where were they? That's the only question I asked him. So I don't think they didn't come in. Nobody put them in during his direct or attempted to put them in during his direct. So to me, it was kind of improper for with me just asking the question, where are the bills? And the simple answer would have been, we received the bills and we have them. Not that here they are and I'm admitting them. You can't admit evidence on my cross-examination.
So I may be misremembering, and I'll let Ms. O'Neill flesh this out from her recollection. But first, your question wasn't just in a vacuum, like, oh, that's interesting. Do you happen to know where the bills are? It was well, where are these bills? You say it's a big number. Where are they? My words, not yours. But to me, that was the gist of your perfectly appropriate question. You're going to drop on us a figure of $330,000. Where are these bills? And lo and behold, on redirect, they were there and they were sought to be admitted. And it doesn't seem to be an improper use of redirect to get them in. They may physically have been put on the stand while you were doing your cross-examination, but I don't think, but I may be misremembering, that Ms. O'Neill interrupted your cross-examination and said, you know what, we tender plaintiff's 281. That would not have been the right way to get evidence in. If you weren't interested in tendering it as your witness, you control if something's tendered at that time.
Okay, let's assume they are admitted. What are the jurors supposed to do with those bills when there's no testimony regarding the reasonableness of the rates or the time expended? It's a piece of evidence that they don't have sufficient information to analyze per the law, which says that you gotta have some testimony regarding the reasonableness of the time and the rates. So what are they to do with those documents? And if they come back and put it on jury form that we award $330,000 in attorney's fees, and that's gonna be erroneous.
Okay. Is my recollection consistent with yours, Ms. O'Neill, that on redirect was when you tendered plaintiff's 281? Or did you somehow, in the middle of Mr. Kendall's cross-examination, seek to tender plaintiff's 281?
Yeah, it was on record.
Okay. All right. So I'm going to go work a little more on the charge. I will also think a little bit more about fees. And when I come back out with the draft charge for you all, I'll actually come out to give you the draft charge and go away a little bit so you can read through it. And then we will discuss the draft charge as well as we won't discuss. I'll let you know what I'm doing with the fee piece of damages in this case. The only other thing I have on my running to-do list was, I fear it may appear elsewhere, but Defendant's Exhibit 83 was a document that has Dr. Dalton's home address on it. And we need to redact that. And there may have been more than one of those because I can't remember if it was like a wire or something. It's a business document. It's not a handwritten note. I just want to make sure, I want this in both directions. I don't know if Mr. Hyder's home address is on documents, but let's make sure in things that are going out with the jury, we don't have any personal identifying information. The hallmark of being extreme in that is that Amex bill that is almost entirely giant pages of redaction, and there's this one entry. But let's make sure for exhibits that have been admitted, we aren't sharing with the jurors and ultimately the record. addresses or things like that.
Now, are we sending out hard copies? We're gonna be sending out hard copies.
Unless there's an exhibit that you think shouldn't because of some rule, but my vision is that there'll be a set of everything that was admitted, whether you have it in binders or all stacked up, it's up to you all. But if this would be a great time to confer, to make sure that there's general agreement on what was admitted and what wasn't. And then in that universe of was admitted, what goes out to the jury? Because I think there's at least one thing that we admitted for the record that Ms. O'Neill said, I know this won't go to the jury, but I want it to be part of the record. It was the consent from the Vaknin's lawyer to, so there may be things that one side or both sides believe should not go back with the jury. If you could start thinking about that now, while I'm working on the rest of the charts, that would help. It's frustrating to the jurors if I give them their final instructions and then tell them, but you can't deliberate till we bring you the 8,000 exhibits. And it'll take a while to get all the exhibits in place. It's 7 binders, not all of which was used. It's 2 binders, not all of which was used. So we need that subset, it's a big subset, of exhibits that were admitted.
We have one issue on that, which I do think should be on the record. I'm happy to confer, but we have the audio. And we did admit all of them into the record. And what we would propose, and I'd like to put this on record because I think there'll end up being some discussion about it at some point. We have a completely scrubbed laptop, nothing on it. Happy to let Mr. Kendall and everybody else look at it. If they wanted to play it, they can play it. The problem is, in theory, if the jury wanted to disregard the court's instruction and get on the public Wi-Fi and do some internet research while they were back there, they could do that. Now, they could do that on their phones, so I think that the same risk would apply, but I want to put that out there because in this case, we do have some electronic only exhibits.
So I'll hear from Mr. Kendall, but he may not have much to say after I share with you how it will work. Jurors don't have their electronic devices during deliberations. Deputy Gordon collects them, and I have a little box in my office that beeps all afternoon long because I have all their devices. They might be tempted to research, but they would have to have an internal antenna and a tinfoil hat to get something. And it's for that reason they don't get an electronic device like a laptop to watch a video that's in evidence or listen to audio. If they want to listen to something, they'll need to send a question, a note through the deputy, and then with all of us here, we will play whatever it is they want to listen to. If they want to rehear something that was shared, there's much that's in that wasn't played. They may say, you know what, we were kind of interested in what they'd be talking about on April Fool's Day. We want the call from there. And if they want to listen to that, that's their prerogative. Mr. Kendall, a differing view?
No, that's fine.
Okay, so you can save the scrubbed laptop. All right, I'll be back in a little bit.
May I be excused?
Yes, as may Madam Court Reporter. Thank you. We'll see you a little before 9 tomorrow.
Just my clients may decide to leave as well.
You can tell them how fun it's going to be, and if they want to stay, they may. And if they don't, that is not a problem.
Thank you. Yeah, give it to me. That's what Someone good to see you again.
Look at the list, let's keep track. Can't find my list.
Well, whenever you come over, yeah, I'll be here. Okay.
I'm just. Our side.
Ms. Courtroom, do you have been keeping a list of the exhibits? Or you just like take it in? Or
I took it in about recording, but rather than the transcript, I got some of the.
citizen transfer. Have you done all the transfers for today? Yeah.
Oh.
Yeah, maybe a rush of it. Jury issue.